Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Prosecutor, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. My friends, thanks so much for coming to hang out with me today. Today is Friday, January 30th of 2026. January 30th of 2026. And yesterday marked the 4-year anniversary of Boston police officer John O'Keefe's death. 4 years. 4 years since John O'Keefe's death, and no matter how much division there is online about who's responsible for John O'Keefe's death, I think we can all agree that John O'Keefe should be alive today. Can we all agree on that at least? And there will be no justice for John O'Keefe until the people responsible for his death or for the covering up of his death or both are held responsible. Will they ever be? I don't know. But what I do know is that a journalist by the name of Aidan Kearney, some of you may know him as Turtleboy. He's been doing this for, I don't know, probably 15 years, uncovering corruption in Massachusetts and other places. Aidan Kearney is being prosecuted for witness intimidation, for doing old-fashioned journalism, knocking on doors, asking questions. And he's facing up to something like 90 to 100 years in jail under the statutory guidelines of witness intimidation in Massachusetts. Each count entitles him to something like 10 years in prison. Remember, he's already done 60 days in the Norfolk County Pokey. I think he was in solitary or in medical, not able to socialize with the other prisoners in the Norfolk County Pokey. And he spent 60 days there. They tried to keep him for 90, but then they realized that 90 was unconstitutional. He did 60 days because they really, really, really wanted to shut him up out over there in Norfolk County, Massachusetts. And I don't know. It's just darker lighting today. My hair is the same color. It's just, I have a new setup and I haven't quite figured out the camera. I see you talking about my hair. Thank you. But yeah, I need it to be a little more blonde. I agree. We'll get there. I'm very busy. We'll get there. And so that's what we're doing here. We're standing up for the First Amendment, for freedom of the press. This is outrageous what is going on. And what I find to be I'm outraged about a lot of things, but what is more outrageous to me is that the mainstream media is nowhere near this case. Nowhere near this case. I remember people like Brian Enton practically camped out on the lawn of Brian Laundrie's parents in Florida. Am I making that up? Why is it some states treat things like that differently. And journalists are allowed to knock on doors. Remember the To Catch a Predator kind of stuff? In the old time 60 Minutes, news reporters knocking on doors, asking questions. Aidan and some other people released some text messages last night. I can't authenticate them or verify them, but it seems that JenMcCabe and her cohorts were actually following Aidan Kearney around back in, I don't even remember when that was. I think it was sometime in March 2024, I want to say. And it's wild to me that this woman is going to say that she's afraid of Aidan Kearney because that's part of the witness intimidation statute. That's what they need to prove. How is she afraid of him if she's actively, if these are authentic, these text messages, going around with her friends or who she thought were her friends to follow him around Southie and take pictures of his car? How is she afraid of him? It's wild to me. How's Chris Albert afraid of him when he's threatening him outside of D&E Pizza? And something else that I noticed. All right, so those messages are from March of 2024, March 4th of 2024. You know what's so interesting about that? With all the stuff that's come out about Brian Tully and his internal affairs investigation. I'm frozen. It's a StreamYard issue, guys. Everyone's having this problem. I'll move over here. Brian Tully, Michael Proctor was called to testify in front of the grand jury. If you can still hear me and I'm frozen, hopefully I won't be frozen. I don't know, you guys. I just can't. I can't deal with it today. It's a StreamYard issue. It's everyone. It's having this problem. Now I lost my train of thought. February 2024. That's when Michael Proctor was called to testify in front of the federal grand jury, right? Right? The next month, in March of 2024, JenMcCabe, two other women, one of them I think is a girlfriend of one of the other Albert brothers, and Lindsay Gattani, they roped her into this whole thing, were following Aidan Kearney around in March of 2024. Remember, February of 2024 is when Michael Proctor was grilled in front of the federal grand jury. Then Tully and Fanning go to meet with him, and that happens to be the same exact month, according to Proctor's own attorneys, that he destroyed his phone and set everything to delete every 30 days. And joke's on him. Joke's on him because when Judge Krupp ordered Proctor's attorneys to hand over his physical phone to the Commonwealth back in August of 2025 to extract the entire thing, Proctor's attorneys said, oh, yeah, about that. Well, here's the thing, Judge Krupp. Proctor got a new phone in February of 2024. And what had happened was he said everything to delete every 30 days. So you're not going to get anything. You're just not going to get anything. And they were like, okay, well, we're going to try anyway. And they did a total phone extraction and they got 13 years. They got hundreds of thousands of items going all the way back to 2013. Right? It's all very convenient timing. Does it show consciousness of guilt to you? Maybe. You know, don't leave your common sense at the door, people. Don't leave your common sense at the door. The hearing is supposed to start at 9:30. I have a Zoom feed up and I have Justice Served, I believe, is also going to be streaming it. I don't know if any mainstream media is going to be streaming it. If you do, you can email me the link. I'll put my email up here, fanbase@mlittleLaw.com, because I don't know if Boston 10 is going to stream it. I don't know if WCV, whatever the local stations are, Boston 25, if anybody's going to be streaming it, because they've basically walked away from this case. And you would think that they would be so interested in this because it affects journalists' rights in Massachusetts and freedom of the press. And what it also affects, maybe you don't know this, but Massachusetts is one of only a handful of states that does not recognize any sort, here's my email at the bottom, any sort of journalistic privilege at all. No confidentiality. There's no such thing in Massachusetts. So if you're going to practice journalism in Massachusetts, you can be forced to reveal your sources. You can be forced to give up your notes. We saw that in the Karen Reed case with the Gretchen Voss interviews and the Dateline, Nightline. There is a Zoom. There's a Zoom. The Dateline, Nightline interviews, they had to give up all their cutting room floor stuff and some of their notes. And that's a problem for journalists in Massachusetts, right? So there's that. Trolls are out in full force today, mods, just so that you know. I know I am not on state aid too, but congratulations for your 3 minutes of fame that you just got. It's amazing to me that I set this to a 3-day subscriber level to be able to chat because it's a privilege, not a right. And people will wait 3 days just to go on here and troll. Your tenacity is admirable. It's admirable. Good on them. What's going on out there in the world of social media and the division of the Free Karen Reed movement is disturbing. It's upsetting, and it just it makes you wonder if this wasn't the intent from the beginning by certain players, certain agents of chaos. Remember, I warned you about those agents of chaos and the rage baiters, and I told you they were going to come for you. Oh, and they're coming. They're not just coming; they're here. They're here. To my knowledge, and I was just looking at mass courts, but I just logged out of it by accident. Mass courts. I don't believe that Robert Cosgrove has even opposed this motion to have him disqualified. Chaos Muppets. Well done. I don't believe he's even opposed it. I haven't seen any opposition papers, and I don't know. Trolls don't like the cold. Oh, here's another thing I was thinking of yesterday when I came home from Cancun, because I was in Cancun with my boyfriend Dave Matthews. And I got stuck there for 2 extra days. What a shame. But when I got back to New York and I get off at JFK and I'm waiting outside, it's like the wind chill is 4 degrees. Okay. What was the temperature on August 29th, 2022 in the early morning hours? Anybody remember what the temperature was outside? I submit to you that if you were to stand outside or to lay down outside on a lawn in 4-degree weather, or 12-degree weather, I don't remember what it was with the wind chill, with no coat and 1 shoe and no gloves, that you would be so frostbitten by morning that 5 or 6 hours later, your fingers might be black. I looked at the, I don't remember John's fingers being black or his toes or anything like that. Do you? Because with the wind chill, you can get frostbite in 5 to 10 minutes, depending on how cold it is. You don't have to believe me. Just look up the chart on frostbite and you will see. Let me see if he put in any papers like this morning. No, nothing. Nothing. Well, hypothermia is different though than frostbite, right? It's different than frostbite. Not the same symptoms, isn't it? Let me just check something out here. Every time I go off the screen and I'm on another screen that's on the same screen, it tends to freeze. And this has been a problem with a lot of streamers from StreamYard. Oh, thank you, Elaine, for your very generous $100 Venmo. Good morning to you too, Elaine. Good morning. Good morning. Thank you very much for your very kind and generous donation. Yeah, there was no frostbite, but you guys have seen pictures of people with frostbite, right? People that get stuck in avalanches and stuff. Their fingers and toes turn black. Hello? Hello? Okay. Hold, please. I'm waiting for Justice Serve to put their camera up because I don't see any Boston 10. No live stream, no Wi-Fi in the courtroom, says Blessed Beyond. Okay, we're going on Zoom. I'm going to ask you all once and very kindly, please, for the love of the traveling Mary, please, if you are on the Zoom in court, make sure you're muted before you get in that room, because I don't want anybody hearing my voice again. I'm going to go into the Zoom and then I'm going to zip it, because it has happened way too many times. It's trolls and others. Okay. Who do this every single time we go live. Okay. I'm just going to put it up here so we have it. Also today at 2 p.m. is the renewed bail hearing on Alex Green at 2 p.m. in front of Judge Kearney. Do you guys want to watch that with me? Because I've got Zoom info for that too. Alex Green is a man who shot point blank in the face another man outside of an Irish pub Saturday before St. Patrick's Day. He's charged with first-degree murder. And he was denied bail the first couple times. The case was transferred from the Cape to Plymouth Superior. And once Judge Kearney got involved, she agreed to let him out on $100,000 bail because of his diabetes. Okay? Because he has diabetes. Have you ever heard of a first-degree murder charge in Massachusetts of an adult? This is a grown man who was supposed to start working with the Barnstable Sheriff's Office the following week. And Judge Kearney, after many months, allowed him out on $100,000 cash bail. And they are going to rehear because the DA has asked for reconsideration of that bond. And that's happening at 2 p.m. And I've got all the info. If you'd like to cover that, I'm sure that we can do that together. Otherwise, I'm just going to watch it by myself anyway. That's a motion for reconsideration on bond. That's in Brockton, in the Brockton Courthouse in Plymouth County. Front of Judge Kearney, 2 p.m. Kevin Reddington and Rosemary Scapiccio now represent Alex Green. And it'll be interesting, you know, to see if the law is applied equally throughout the state of Massachusetts, because we know that it's not, the Commonwealth, rather. We know that it's not. Because Kelsey Fitzsimmons, do we need to go much further than Kelsey Fitzsimmons? Yeah, they did everything to keep Kelsey in jail. But Alex Green, no, we're going to let him out, because apparently also there's some reports that on the way, after they put him in the patrol car and they were taking him in, after they arrested him for shooting this man point blank in the face and killing him, he was saying in the car, according to the dash cam, don't you know who I am? Don't you know my family, my family, my family? Don't you know who I am, kind of thing? I'm summarizing. So there's that. They're telling me that Justice Served might not be able to live stream because there's no Wi-Fi in the courtroom. Because, you know, listen, I've got the Zoom up, so we're good. Remember, they just got Wi-Fi in the Dedham courthouse the week before Karen Reed's first trial. Remember? Yes, Craft Haskell says Jen McManus forgot to Google Hoslong for frostbite. Yeah, there's a chart. You can find it. It's easy. Just Google it. Google frostbite chart. It comes right up. Hold on. Hold, please. Thanks to Paula Kincaid for upgrading her membership to floor seats. Notice all of my categories are based on concert tickets. Thank you, Strange Credulity, for gifting a membership. Hello to Ireland. Good morning, 44. Mrs. Bouquet has been here for 21 months, and she says, I love you with all of my heart. Proud to be a cupcake. Harrison says hi. Hi, Harrison. And Mrs. Bouquet from across the pond. Channel 5 is there, okay? WCVB, all right. We'll see if they're going to live stream it. Let's see. In other news, Saxaw Fifth is closing most of its stores, including both locations in Massachusetts, which is upsetting because Saxaw Fifth was a great way to get really high-end brands for less. They don't sponsor me either. Let's see. Hold, please. At least there's one media outlet there. At least they care. I don't see that they're going to stream it live, though. They might be taping it for later. How about those Patriots, huh? How about those Patriots? I'm going to try and not talk so much just in case the Zoom starts. Oh, the glare is there? Is he here? Is he here in the chat? Pool camera just arrived. You should be able to stream. Thank you, Glare. Is it I heard it was Channel 5. It's WCVB. But I have the Zoom up anyway. All right. You guys are on it. I love that for us. Thanks, Not Fade Away, Kai. 9 months of outrage and love every minute with you. Me too. Thanks, Kai. Proctor Files is here. Oh, Karma's a bitch. Love this for Proctor. Thanks for being here for 11 months. Rosie's Overruled says, I love cupcakes, Melanie's and mods. Thanks for being here for 4 months. Cupcakes for Justice. Thanks for your $8 super chat. Member for 8 months. So glad I found you. I'm so glad you found me too. Johnny's been here for 16 months. How was Cancun? Free travel was amazing. It was amazing. It was 85 every day. 85 every day and sunny. But then because of the snowmageddon here, I got stuck an extra 2 days. But it was 3 days of Dave Matthews and Tim Reynolds playing on the beach. Channel 7. Thank you, Will. Let's see, Boston. What is Boston Channel 7? That is 7 News. Let's see. Oh, please. We'll just get it all up. If I freeze, just don't worry. I'll be right back. Did Will, are you in the court? Yeah, Will, did Will go in person? I thought he was going in person. Yes, Fish was coming in, Kai, as I was leaving. Fish was coming in. The Fish fans were coming. Free Turtle Boy, he says Johnny. Jenny Lulu. Let's do this. Free Turtle Boy. Thanks for being here for 13 months. Kyle's here. Hi, Kyle. We had a regular patient froze overnight, 17 degrees Fahrenheit. Wow. Thanks, Kyle. South Boston Kev is here. He says, me and Gay Jeff are going to the cottage this summer. You mean Auntie Bev's Seaside Cottage that they were going to bury Aidan Kearney under? Lucky you for getting that invite. Pinky, I sent you an email about the hearing. Okay, but does it say Pinky anywhere on there? I see that you sent me Erica Walsh's feed. I don't know if she's going to be, is that you? Because it's under a different name. So if you're going to use one username on YouTube and one in my email, you got to tell me who you are, because that's the only thing I see here. We have the Zoom, and so we can at least get that, if nothing else. Thanks, Binky. Thanks, Binky, for becoming a member. We have a special emoji just for you, Binky. See, we have a Binky emoji. There you go. In B&B we trust, says 44, meaning Bradle and Betterow. Sub-zero temperatures. in Massachusetts. Thanks for tuning in from across the pond. Hi, Cherie. Just under 90 degrees, 29 Celsius at 1:30 a.m. here. I'm melting. 90 Fahrenheit in Australia. Thanks, Cherie, for being here for 15 months. Thanks, Paula, for becoming a new member. Thanks, Goldie, for your super sticker. Piney Woods, been here for 12. All I'm saying is the rule of law is dying here. Yeah. I say Massachusetts is where your constitutional rights go to die. I say that all the time, right? Hello to the UK, to Dolly. Thanks for being here for 6. On top, thank you for your super sticker, as always. You're a sweetheart. Sparkly Rabbit became a member. Welcome. Cosgrove's Velcro sneakers is here. Says I have my good sneakers on today. You've been here for 10 months. You could be responding to the motion. That'd be great. Kim is the ladybug, has been here for 9. Free Aidan Turtleboy Kearney, she says. Thanks, Kim. Really, I see you. Says typical signs of frostbite do not occur if the person's already dead before put in snow and cold. Okay, so if he died somewhere inside the house or somewhere else and then he was put outside, then you wouldn't see the black fingers and toes, right? I can't keep their theory straight. Was he killed immediately? Did he live? Because he was showing signs of life when they went there. Remember? He had breath sounds bilaterally. So I don't know. But I'm just saying. Thanks for your 10. Not here for the drama, became a member. Welcome. And Betty says free Turtle Boy. Thanks for being here for 19 months, Betty. Jersey Queen became a new member too. Welcome. Welcome. Good luck today, Turtle Boy, says Songbits Laura. Glad you're back, Melanie. Oh, thank you. Thanks for being here for 6 months. But post-mortem skin freezing shows sign too. I thought so, Robin J. I thought so. This is supposed to go at 9:30. It's supposed to go at 9:30, but we're here. We're here and we're waiting. Lisa says he would have been frostbitten all over. We have a lot of medical professionals in the chat. So you guys tell me. This is funny. That is very funny. It's very funny, Miss D. Frostbite can happen post-mortem. It's frozen tissue, says Kristen Pino. Right, Justice can't stream, but we've got the Zoom up, and we hear that Boss Channel 7 is there. And so we're just waiting. And if you are on the court Zoom, please make sure you are muted. Thank you so much for playing. It's Wag says at this point, free Massachusetts. Thanks for being up at 12. Dead bodies can get frostbite, says Darlene. Okay, see? Channel 5 is also there, but who's the pool? Is anybody live tweeting from the courthouse? Is Jess Machado there today? Kyle saying that bilateral breath sounds verify ET tube placement. Ventilating doesn't mean spontaneous respirations. Well, they didn't intubate him. They didn't intubate him. They put an IO line in his tib-fib area, I believe, but they did not. He was not intubated at the scene. Was he? I could be wrong on that, but I don't think he was intubated. Thank you very much, Kyle. Oh, our badass affirmation of the day. We might have to wait. Oh, did you see my new prop? Look, it's the world's tiniest leaf blower. Oh, yes, it is. How awesome is that? I have to open it up and then I can use it to like blow the dust off my keyboard or something. Here's our affirmations for a badass. We pull one of these every day and it's always very relevant. So let's see what it says today. Here we go. Here it is. Oh, this is a good one. If you have kids in the car with you, mute them. I hear you guys that Erica Walsh is at the courthouse and are they live tweeting? I want to get a feed that has the best audio and video. And so if somebody's just using their iPhone in the courtroom, I don't know if it's going to be as good as what I can give you on Zoom. So my unique spirit brings shit tons of light to the world. There's your badass affirmation of the day. My unique spirit brings shit tons of light to the world. There it is. You saw me pull it out of the middle of the deck. It's a good one for everyone who needs an affirmation today. Oh, Justice here. Were there any anti-Aidan supporters that showed up outside the courthouse? Anyone? Are we aware? Because I heard there was a call to rally for everyone to go and oppose Aidan Kearney. Brutal conditions, says Scott McGinnis. Say the problem with that court plaza is it's always windy anyway, so brutal conditions today. Jess is sick. Hi, Jess. Tashai says, hey, Mel, please do House defendants motion to dismiss. Please, I need to laugh. You can do that later, like at 5 o'clock. How about that? I wanted to cover Brendan Banfield with you yesterday, and he did take the stand, and the testimony was everything, but I had an unexpected thing that I had to do and with someone. And so just shout out to the oncology nurses at NYU. Langone, you guys are the best. You know it. And oncology nurses, we say a lot of times there's a lot of people doing the Lord's work, but oncology nurses are special. They really, 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 really are. Most haters don't have the balls to show up, says DW again, with a very, very, very creative emoji collection. Channel 5. All right, we're still waiting for the Zoom to start, though. And so we're here. We've got all of it. We're here for all of it. But too many tabs open may mean that I'm going to freeze. I don't know. I don't know what's going on with StreamYard. For the amount of money they charge every month to use this platform, it's declining. In my opinion. But I think a lot of streamers have been having trouble with freezing, right? So it's not just me, because I did get a whole new setup that is so much more powerful than what I had before. And I just, oh, she can't stream inside. Okay. And so I thought maybe I had, everything hooked up wrong, or like the cables, I need the Geek Squad. And you guys said that it's happening to everyone. And Diane Gallagher is beginning a 5-week radiation and chemo treatment on Monday. God bless you. And I wish you all of the healing vibes. And I hope that your oncology nurses are amazing also. And they are. Pro tip, buy one off of Amazon, a heated throw blanket while you're in your chemo chair. If you're doing infusion therapy, a heated throw blanket, they're like maybe 20, 30 bucks. You can get them at TJ Maxx or on Amazon, and they're amazing. Highly recommend. Okay, so Erica Walsh was streaming, but she can't stream inside the courthouse is what you guys are telling me. See, Buff someone said, OMG, my buff was just hospitalized in Denver and put in the medical surgical oncology ward. Those nurses are next level. I got Boston quality care. I'm so sorry about your kid. They're amazing. All the healing vibes to your kid as well. Thanks for being with me for 10 months. And let's hope the Buffs have a better year next year. Huh? You think? Maybe? Perhaps? Okay, they just let them in the room. Okay, Channel 5 just got there. She can't stream in the courtroom. Yes, correct. But listen, we can always watch the Zoom, and then when we find the feed with a real camera, we can watch that second, because I don't know how long it's going to be. But listen, we're here for all of it, right? We got no quick. An electric heated blanket. Yeah, is that what I said? Did I say something else? I don't know. I don't know. Listen, I got one of these heated throws. I don't know what I ever did without it. I also have a weighted one that goes on your neck and shoulders. That's also like 30 bucks on Amazon. So if you have a neck and shoulder pain, that's amazing too. Good luck to Turtleboy. And so we're waiting. We're waiting. I understand. So thank you, Sophia. Justice served is there. The problem is that there's no Wi-Fi in the courtroom, is what people are telling me, and so they're not going to be able.
They say, my coaches say I have really good
Yeah, if you don't mind sliding down, that'd be great. Thanks, Phil. Thank you. At all parties. And Cook, are we ready?
We are.
What are you on?
Court, all rise, please. Honorable court's in session, please be seated.
Good morning, Your Honor. Before the court is the matter of Commonwealth versus Aidan Kearney on Norfolk dockets 2382 CR 00313 and 2582 CR 0088. Mr. Kearney is present. Counsel, please identify themselves for the record, beginning with the Commonwealth.
Good morning, Your Honor. I'm Robert Cosgrove.
Good morning, Attorney Cosgrove.
Good morning, Your Honor. Timothy Bradle on behalf of Aidan Kearney.
Good morning, Mr. Cosgrove. Mr. Bradle.
Before Mr. Carney, Mark Betterow. Good morning, Your Honor.
Good morning, Mr. Betterow. Okay, just to be clear, we've accommodated as many people as we can in the audience. I understand there are some folks outside. The court has opened the matter to Zoom primarily because of the weather and the parking conditions. I'm not going to say that we're going to have it on Zoom every single time, but to those who can't be in the courtroom right now, we are broadcasting by Zoom. I further note the court was prepared to come out at 9, but the delay was due to the late arrival of some of the counsel. So with that, I would remind all parties who are attending by Zoom that any rebroadcast, if you are not qualified under SJC Rule 1.1119, rebroadcast is prohibited. Those who are qualified and have registered are certainly free to rebroadcast as appropriate.
We're out. We need another. Who's got a live feed? I can't do it. I'm on the Zoom. He's not streaming. Bigger than another country. Broken Baker is streaming it, and we're gonna stream Baker. So hold on. He'll be cool with it. Hold on. He's in another country, so I guess he doesn't care. I'm not risking it here. Okay.
Be removed.
We're gonna take it a little bit back. The judge is spanking Betterow right now.
For the recusal or removal of
All right, can you hear it?
accommodate as many people as we can in the audience.
Okay, here we go.
Good morning, Your Honor. Before the court is the matter of Commonwealth versus Aidan Kearney on Norfolk dockets 2382 CR 00313 and 2582 CR 0088. Mr. Kearney is present. Counsel, please identify themselves for the record, beginning with the Commonwealth.
Good morning, Your Honor. I'm Robert Cosgrove.
Good morning, Attorney Cosgrove.
Good morning, Your Honor. Timothy Bradel on behalf of Aidan Kearney.
Good morning, Mr. Cosgrove. Mr. Bradel.
For Mr. Kearney, Mark Betterow. Good morning, Your Honor.
Morning, Mr. Betterow. Okay, just to be clear, we've accommodated as many people as we can in the audience. I understand there are some folks outside. The court has opened the matter to Zoom, primarily because of the weather and the parking conditions. I'm not going to say that we're going to have it on Zoom every single time, but to those who can't be in the courtroom right now, we are broadcasting by Zoom. I further note the court was prepared to come out at 9, but the delay was due to the late arrival of some of the counsel. So with that, I would...
You know what's real interesting about that? Is that it was on the calendar for 9:30. I have a calendar in front of me, and it says 9:30. Let me see if Boston 5 Live has it. We can pause Baker, so we're okay on that.
Remind all parties who are attending by Zoom that any rebroadcast, if you are not qualified under SJC Rule 1.1119, rebroadcast is prohibited. Those who are qualified and have registered are certainly free to rebroadcast as appropriate. So with that, my intention today is to cover papers 110,
Blaming the lawyers.
117 in part, 125, and 127. Those are the matters which deal with the request for the recusal or removal of Mr. Cosgrove as counsel for the Commonwealth. Now, before we begin that, particularly Mr. Betterow, just to you, and I know Judge Doolin may have talked to you about this a little bit. Going forward, we don't file affidavits as motions.
Here's what he does. This is not the way we do things in Massachusetts, Mr. Betterow.
Rule 13 requires a motion to be a motion. It can be supported by a memorandum of law. It can be supported by an affidavit. The matter we're here for today, there is in fact no motion on file. I'll take it as it sits because it's been responded to. But going forward, if you want to file a motion, it has to be a motion. It has to be clearly captioned as to what you're looking for. Further, it has to deal with one subject at a time. I'm not going to do motions that deal with the entire kitchen sink. It's going to be one motion at a time. It's going to be clearly noted. If you want to put a memorandum of law, again, you have to reference the motion you're dealing with. Further, if you want to put an affidavit, the affidavit has to reference the motion that you filed. If you want to put in a
This is Judge Belezos. This is Judge Belezos. He's sitting in Suffolk County, but the case is a Norfolk County case.
supplemental motion or supplemental memorandum, it has to list the paper number that you're talking about. Going through this over the last several days and trying to figure out what I'm dealing with took an amount of time, which is kind of absurd because I'm trying to trace back what you're talking about and I can't find the motion because it doesn't exist. So I understand you're not local to Massachusetts. Mr. Bradel is extremely experienced and quite good at drafting these things. So
Because I was going to say, that's my fault. I'm local counsel. I should have made sure that that was that way, and we'll make sure that going forward.
And I note that paper number 127 is more in the form that we used to in this court. So I just want to remind everybody where we're at. And again, not familiar with the area, that's okay. Just going forward, I don't want to have to sort of parse through what we're dealing with, nor do I want to have to hear from Mr. Cosgrove saying there's no motion filed, because it's a pretty good point on his part. So with that, let's take up the matters that are before the court. You're the moving party. I don't know who wants to argue, Mr. Bradle or Mr. Federo.
Mr. Bedero, Your Honor.
We'll hear from you.
Thank you.
Understand, I've looked at all your motions as well as all of the exhibits.
May I, Your Honor?
You may.
Counsel states that a recent conflict of interest has developed, which ethically precludes him from continuing to prosecute matters in which Lindsay Gaetani is an alleged victim or party. Those are the words of Mr. Cosgrove on September 24th, 2025, regarding his request to be removed from another indictment in which Lindsay Gaetani was a witness, and we'll get to in this argument why she may very well be a witness in this case.
Witness is different from victim, correct?
I'm sorry?
Witness is different from victim, right?
Of course, but as we'll get to, Your Honor, if a prosecutor or anyone has a personal interest that may differ from Commonwealth's or to a defendant's right to a fair trial, that's something that has to be factored in. The point of that comment, Your Honor, is that Mr. Cosgrove acknowledged that there was a conflict arising out of Ms. Gaetani's claims against him. She has accused him of unprofessional and unethical conduct and has sued him. He draws the line.
I note that the last docket entry in that case was it was in the process of being settled. That's paper number 15 on that case that was filed just last week.
Judge, whether the civil case continues or not isn't even necessarily the issue.
Explain why that would not be a problem.
Because she has accused him, a lawyer, a former judge, of unethical behavior, and he has a personal interest, understandably so, in defending himself against that. And in any matter in which her credibility becomes an issue, as she testifies in a trial, he has an interest in discrediting her, which may be very different from the Commonwealth's interest, which I'll get into as to why that may be. But the point is, calling her an alleged victim and that there is a conflict because of her allegations against me, merely being a witness in a case in which she may testify, as the difference which somehow makes his personal interest, acting both as a criminal prosecutor while serving as a civil defendant and potentially cross-examining your civil accuser and your lead detective, is a civil co-defendant who has also been accused of misconduct, undermines the public confidence in the proceedings and demonstrates that a prosecutor could have a personal interest. The bottom line, Your Honor, the difference between witness and alleged victim is a distinction without a difference if the prosecutor has a personal interest which could significantly impact his representation of a party in the case. That's the Rule 1.7 issue. Now, Mr. Cosgrove has replied that, well, we're not going to call Ms. Gaetani as a witness, and that certainly is right for the time being anyway as the prosecutor for the Commonwealth. But the defense may very well call her. Her credibility will be an issue, obviously, if she testifies in this case. At that point, having a prosecutor who has been accused of misconduct, who is named as a civil defendant, attacking her credibility and attempting to defend the credibility of other witnesses whose credibility could be impeached by Ms. Gaetani is a problem. It's a problem because the jury would have a right to know what the prosecutor's interest may be. It's not...
Well, he chose not to cross-examine her.
That's a decision that has to be made by a disinterested prosecutor.
What if you got someone else to cross-examine her?
That may or may not solve the problem. Certainly it would with the direct examination of her.
I feel like I'm in the Twilight Zone. I feel like I'm in the Twilight Zone. This is so basic, this conflict. It is so basic. And Betterow having to explain himself, I can see that his head wants to pop off right now. This is wild. Hold on. Taking that back a moment.
That has to be made by a disinterested
Right.
What the prosecutor's interest may be. It's not...
Well, he chose not to cross-examine her.
That's a decision that has to...
What if he chose not to cross-examine her? He can't be involved in the case at all. That's the point.
be made by a disinterested prosecutor.
What if you got someone else to cross-examine her?
That may or may not solve the problem. Certainly it would with the direct examination of her.
But he's not going to call her. He's made that clear.
I understand that. What I'm suggesting to the court is we may very well do that.
You may, and you'd have to get permission from the court to do that because you'd have to show me that it's relevant, but that's another issue down the road.
Well, I'm going to tell you right now, respectfully, why it may be relevant beyond just the substance of her testimony. Mr. Cosgrove addressed the substance of her testimony as it relates to the allegations against Mr. Kearney. She also may very well be a witness who can expose bias of other important prosecution witnesses, who could expose conduct on behalf of some of those important prosecution witnesses, conduct which is not at all consistent.
Well, let's get to the nub of it, all right? Because I've read all your material, so you don't need to repeat the argument to me. Look, as I understand the issue here, Ms. Gaetani, that's the correct pronunciation, is it not? Ms. Gaetani has an interaction with Special Prosecutor Mello in December, I think the 24th, was it, or the 23rd?
Something like that.
Of 2023.
Mm-hmm.
It's around that time that she's alleged to have some interaction with Ms. McCabe. Is that correct?
Amongst other times, yes.
Well, around that time is my understanding, based on the evidence you presented me. Around that time, Ms. McCabe urges her to go to the grand jury. Do the right thing, go to the grand jury, something along those lines. All right, is that correct?
In substance, but I think it's interpretational, and the witness might expand upon that.
I understand that. All of those events occurred 6 months after the events that are in play here. So the relevance of those events is only as to the credibility, potentially, of Ms. McCabe. Now, you might be able to get into that. You might be able to even confront Ms. McCabe. But then you're going to have to raise an issue of whether or not you get into a trial within a trial, so to speak, the extrinsic evidence rule, which takes us to whether or not she is even going to be a witness to talk about potential bias after the fact. This is after the fact bias.
Yeah.
On an issue which, frankly, I'm struggling with a little bit, because nobody contests the acts here, all right? Mr. Kearney is a citizen journalist, sort of a new breed of journalists, correct? He presents to this court that all of his activities are fully protected under the First Amendment. Very reasonable argument, okay? Mr. Cosgrove says different. He says this is witness intimidation. The motivation of Ms. McCabe to his acts is tangential by and large, is it not?
Judge,
now she's going to testify, yes, I was intimidated. But the main factor here is the nature of the comment, which is recorded, made voluntarily and recorded. Now, you are correct. There's an excellent argument to be made, perhaps, that Gaetani and Genduso and McCabe may have all had some idea that they were going to get together and get his bail revoked. But that's not what this trial's about. This trial's about what happened 6 months before. So you got to draw me to the relevance of that.
Well, her bias and motive against him, whether before, during, or after, I would suggest is certainly relevant. Moreover, it's
all after. There's no before.
Judge, you mentioned a moment ago about the fact that she's going to come in and say, I felt intimidated or I was emotionally harmed. I think we would all agree that would be relevant about what the impact that these horrible allegations.
I just want to make better a little bit bigger. This is
Had on
insane.
her.
First, the judge is confused. He doesn't know what paper goes where. Then all of a sudden he knows all the facts. Now he doesn't care because he's talking about Genduso and Gaetani, and they're all after the fact, not before the fact. I am officially in the land of the lost, and that's why Chaka is up there on the right-hand corner of your screen, because this is insanity. They served Lindsay Gaetani with a grand jury subpoena to testify in front of the grand jury for the 2023 allegations for all of the witness intimidation for Jennifer McCabe, Matt McCabe, Michael Proctor, Jerry Buchanan, and everybody else. And now the judge is saying, well, they already said they're not going to call Lindsay Gaetani, so it's not a conflict. This is so basic that it's made my head pop off. It's on the ferry to Connecticut. Can somebody pick it up, please? I'll send it to Mystic, New London.
Evidence through electronic communications between Gaetani and McCabe which Gaetani may very well have to authenticate as a witness, because frankly, we don't assume or take any guess what Ms. McCabe will say, where shortly after Mr. Kearney was released from jail, from what Your Honor just spoke about, where Ms. McCabe recruited Ms. Gaetani and orchestrated surveilling him from various police stations and to other locations, joking about going on a stakeout. In other words, conduct not consistent with her being intimidated. Those actions will also
Well, the intimidation doesn't have to last forever. Intimidation, we're only trying one slice in time. That's the bedrock of any criminal defendant, right?
But
not trying his entire life, we're trying that moment.
But these are questions that have to be posed to Ms. McCabe, and she'll have and should be forced to answer them and explain them.
I don't necessarily disagree with that.
Okay, so the point is, we don't know what Ms. McCabe will say. We know based upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
Which seems to move with time from poll to poll, correct?
I'm not sure what you mean.
Well, it seems like her allegiances have changed as this case has developed.
She is, without question, a unique.
Okay. We know there's been no opposition filed to this motion. Okay. It's not in the docket. Cosgrove has not opposed this. So is the judge reading Twitter for his information? The judge just said Lindsay Gaetani's allegiances have changed. How does he know that? Cosgrove didn't put any papers in there. Is he reading Twitter? Is he going to Reddit? Is he on a Discord group? I am way confused. Mark Better has now brought up those text messages so we can look at them after this is over. Those are the ones that I was referencing in the beginning of the stream. How does the judge know this information? Because I don't think it says that in any opposing papers. Does it? It might, but this is wild. Listen, I'm going to take it back.
McCabe will say, we know they answer them and explain them.
I don't necessarily disagree with that.
Okay, so the point is, we don't know what Ms. McCabe will say. We know based upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
Which seems to move with time from poll to poll, correct?
I'm not sure what you mean.
To poll.
Well, it seems like her allegiances have changed as this case has developed.
She is, without question, a unique witness, which raises another interesting point, which could lead to the possible conflict with Mr. Cosgrove. She is a former prosecution witness. There's no question. She testified in grand jury. She testified at a trial called and vouched for by Mr. Cosgrove.
Quite enthusiastically, as I understand.
I believe so, Judge. No question. And at that point, they had no problem.
Quite enthusiastically. Did he watch the stream of the trial? Because we did watch that trial together too. And Lizzie Gaetani testified for Cosgrove. She's now suing him. So in the civil suit, he's going to try and discredit her, Cosgrove. But in this case, he's going to try and bolster her testimony. It is a clear conflict. No, when it's live, there's no closed captions available. Sorry.
With Ms. Gaetani, but at this point, she's now sued Mr. Cosgrove. She has sued Tully. She has threatened to sue or sent a demand letter to the DA's office. And when that happened, Mr. Cosgrove said, I have a conflict with her because he has a personal interest in seeing her discredited. And I'm going back to what I first started with, Your Honor. The issue is not because she's an alleged victim. She's a potential witness in this case, and the prosecutor has a personal interest in seeing her discredited. And the critical part comes in the argument to the jury at the end of the trial. When McCabe has testified, it's in Mr. Cosgrove's personal interest that she be credited, Gaetani not be credited. When Tully testifies, it's the same exercise. He's a co-defendant of his.
What's Tully going to testify to?
Who knows?
Is Tully going to testify? We're not calling Tully.
Mr. Cosgrove, what's Tully going to testify to? Is he even a witness?
I haven't made a determination as to whether I'm going to call Lieutenant Tully or whether I'll need to call Lieutenant Tully. It seems to me that
He doesn't know if he's going to call Tully. This is so, I can't explain to you how wild this is. We're a little bit behind because we had to watch Baker's stream because they said I'm not allowed to stream it. This is wild. We don't know. Cosgrove's like, we don't know if we're going to call Tully. You can't call Tully. He will blow up your case. All this stuff that's been coming out about Tully and his internal affairs investigation, Tully's hands are in everything. But that's not the point here. The point here is that Cosgrove is conflicted. Take that back a few sentences. Oops. Everyone, please go sub up to Broken Baker.
I haven't made a determination as to whether I'm going to call Lieutenant Tully or whether I'll need to call Lieutenant Tully. It seems to me that the videos, which Mr. Kearney has himself made public, documenting his statements and actions, are pretty much self-authenticating.
His actions are pretty much self-authenticating because Aidan Kearney has published some of these text messages. Aidan would just whisper to Mark, if you are not looking at your screen and you're looking and you're just listening while you're rage cleaning or rage crocheting or driving your 18-wheeler. If you can come to your screen, look, I'm going to take it back so you can see Aidan trying to throw him a lifeline here.
It seems to me that the videos, which Mr. Kearney has himself made public, documenting his statements and actions, are pretty much self-authenticating. I'm not sure.
Well, I think you may have to make a choice here fairly quick if we're going to deal with this issue. But continue.
Look, the bottom line is Detective Lieutenant Tully is the lead investigator on this matter. Now, that doesn't obligate the Commonwealth to call him, but he is the driving force behind this. He built the investigation. He got the search warrant.
This is not your classic whodunit.
No.
This is not the investigation where they find evidence on a scene. They develop the evidence on the scene. They trace the suspects. They get phone downloads. They do this, that, the other. This is a very unique set of facts. Where the defendant recorded himself and then voluntarily broadcast his actions to the world at large. So
well, it sounds like you've already convicted him, Judge. It sounds like we don't get the presumption. It's not innocent until proven guilty, because you're just saying, okay, so it's just going to be up to a jury to decide whether or not it's witness intimidation because everything's on video. This is not how the law is supposed to work. This is not how procedure is supposed to be. This is not how the Constitution is supposed to guarantee rights to criminal defendants. This is insane.
The investigation essentially is press record, and then a jury of his peers, all right, would judge the mores of our society to determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
The point I'm
What about all of the improper information that was submitted to the grand jury? All of the videos that were labeled intent and the titles were changed and they were put in a special file and presented that way to the grand jury. What about that, Judge? He might not have been indicted if they didn't pull all of those shenanigans in front of the grand jury, right? It's insane.
Making, Your Honor, is that
are not acceptable First Amendment.
The point I'm making, Your Honor, is that Tully,
and I would like the jury of peers to make that decision. I don't want to make it. I want the jury of his peers to make that decision.
So you're not going to grant the motion to dismiss?
Your Honor, is on this issue.
Okay. So you're not going to grant the motion to dismiss. You're just saying because you want it to go to a jury. He just said that. Let's hear that again.
That Tully,
and I would like the jury of peers to make that decision. I don't want to make it. I want the jury of his peers to make that decision.
Point I'm making, Your Honor, is on this issue is that Tully is the lead investigator. And certainly I can only speak from my own experience, perhaps others, that it would be extraordinarily rare not to call.
I don't find that to be accurate in my experience. I've seen it happen a number of times, much to my disappointment when I sat over there. Okay.
I've seen.
Wow. Yeah, we've seen it happen in the Karen Reed case. They had to walk. They weren't allowed. They didn't call Proctor as the lead investigator because of all the corruption We see you, judge. We see you. You've seen it a lot where they don't call the lead investigator. Why? Because of the corruption. I stop and commentate. That's what I do. If you don't like it, then you can get out.
Seen it happen, and I've taken that from the other side of the table in prosecuting rather than defending, in letting juries know who built the case, what is going on here. But the point,
and fairly pointed out by the defense, and you didn't hear from him.
it could be, it may very well be, but that could also lead to the reason why. Okay, the issues surrounding Gaetani's claims, the defense wants to argue they're not calling Tully. Perhaps the jury may be entitled, not asking Your Honor to make evidentiary rulings now, obviously, but the jury may want to know and be entitled to know why isn't the prosecutor calling him, and might it have something to do with what Gaetani alleges. But moving away from Tully to the larger point, it's not even so much the cross-examinations, or other evidence, which I would suggest are improper, being conducted by a prosecutor with a personal interest in favoring certain witnesses over the one that is suing him. It's the summations, it's the argument. If Mr. Cosgrove has an opportunity to cross-examine Ms. Gaetani, assuming he does, as Your Honor noted, maybe he won't, but I would suggest, again, that's a decision to be made by a disinterested prosecutor, not one with a personal interest.
Well, let's define the personal interest. It is, anybody can bring a lawsuit against anybody, all right? You know, the actions that are alleged here by Mr. Cosgrove, and most of them appear, frankly, seem to have occurred prior to his arrival in the case. But the actions are alleged were done solely in his role as a special prosecutor. You know, his immunity is almost impenetrable, correct?
In a legal sense.
Sir, this is a legal setting.
No, Your Honor, my point is this. Personal interests don't rise and fall. They're not black and white because you've been sued or not sued. She has publicly and loudly accused a distinguished prosecutor of misconduct that he himself recognized after the lawsuit was filed. This lawsuit that we're saying has no merit, what did he do? He sought removal because I'm ethically precluded from cross-examining her. It's the same issue.
Well, I'm not sure about that. I'm not sure that's what he said, but
Okay, first the judge knows nothing about the case, and then he has so much trouble because the papers were not procedurally correct, because this is not how we do things in Massachusetts, Mr. Federal. And now he knows exactly everything that was said, and he knows exactly why Cosgrove withdrew from the Lindsay Gaetani matter, and that those charges, remember, were dropped. They were dropped after Cosgrove had to withdraw. They no pros on those charges. But now he remembers exactly everything that Cosgrove said. And he's right. Betterow is right. It is the same issue. Wow. Kay Willis is here. She's a realtor. And listen, if you guys want to sell your house and get the hell out of Massachusetts, she already gifted 5 memberships today. Kay Willis is your girl. Thanks, Kay.
I'll take that for what it is.
Well, Judge, I just want the record to be clear. What he said was, counsel states that a recent conflict of interest has developed, which ethically precludes him from continuing to prosecute matters when Gaetani is an alleged victim or party. And we talked about whether we use alleged victim or witness as the issue. The point is...
Well, that's why I said that's not exactly what he said. What he said was...
Yes. No, I'm not trying to substitute that. We're trying to, in my view, suggest it's a distinction without a difference, because he has been attacked. And when he withdrew from the other case, the lawsuit against him was no better or no worse than it is now. So he didn't make that argument back then to say, this is some garbage lawsuit, I have no real conflict. What he said was, I am ethically precluded.
All right, I take your point. Mr. Cosgrove, if you're ethically precluded from one, why aren't you ethically precluded from 2? I'll come back to this issue of the 2025 investigation too.
I reserve my answer on that.
Reserve it for when?
when it's my turn to speak.
I was about to give you your turn to speak, but I'll go back to Mr. Betterow. Let's talk.
He said, Cosgrove said, I'm going to reserve my comments or something. And he said, well, until my time to speak. Well, it's your time to speak. Betterow's not done yet. What Cosgrove is what, saving up all his best for last? What is going on here? Chaka, we're in the land of the laws. What is going on? I want to hear that again.
From one, why aren't you ethically precluded?
I am ethically precluded.
This is more like an appellate argument. Like this judge is now like asking them questions, interrupting Betterow, not letting him speak, putting them on the spot. This happens in appellate court. I don't know this judge's background, but I'm going to look it up. Because he did say something like, oh, I've seen that plenty of times when I was sitting over there, as if he was a defense attorney or a prosecutor. And, you know, the Commonwealth never calls the lead investigator, apparently, because they're all corrupt. And because they're all getting, you know, internal affairs investigations against them.
All right, I take your point. Mr. Cosgrove, if you're ethically precluded from one, why aren't you ethically precluded from two? I'll come back to this issue of the 2025 investigation too.
Remember, the 2025 investigation is the window intimidation case outside of D&E Pizza.
I reserve my answer on that.
Reserve it for when?
When it's my turn to speak.
I was about to give you your turn to speak, but I'll go back to Mr. Betterow. Let's talk about the 2025 investigation.
And Your Honor, can I make one point I didn't get to? We kind of
Sure.
got. It's the summations where the real problem arises here. Because if Gaetani were cross-examined by Mr. Cosgrove, in essence, it is almost a free deposition. It is sworn testimony of her by a litigant against another litigant in a civil matter in which he has the full power of the government cross-examining, which will benefit his personal interest. Then you go to summation. Presumably, his argument will be Gaetani is not believable, Gaetani is not credible, but McCabe is. Now, those are appropriate arguments by most people to make, not him, because it is in his personal interest, not just as a representative of the Commonwealth. It is in his personal interest that she be discredited. And the jury should know that. Now, I'm not saying that's an appropriate outcome either. The appropriate outcome is that he be removed, because if he's vouching for the credibility, not in an illegal sense, but advocating for the jury to adopt JenMcCabe and discredit Lindsay Gaetani, the jury should not be ignorant to the fact that this guy's getting sued and wants her to be discredited. That is not the kind of thing that the public can have confidence in when they find out that the prosecutor who is judging everyone's credibility is discrediting her, crediting another, and it's tantamount to him giving unsworn testimony.
This goes back to the issue of relevance that we talked about before, and this is where I'm a little bit hung up. What McCabe does 6, 8, 10 months after the allegations here, because the allegations with regard to McCabe, as I can tell, they occur on 6/6, 9/20, and 7/22. Those are the 3 dates where she's alleged to have been intimidated. So none of these matters involving Gaetani develop until perhaps December, right?
Gaetani's, some of her testimony, though, Judge, will corroborate other evidence we have of JenMcCabe's pattern of surveilling Mr. Kearney.
But when
before he was indicted.
But when?
In 2023, July of 2023. We have documented evidence of her, the intimidated and emotionally harmed witness, contacting Mr. Kearney on social media and alluding to the fact, I know where you are, which is exactly what we're talking about with Gaetani.
That's a fair point to cross-examine her on, no doubt.
Don't know what she's going to say. From our perspective, having seen some of her other testimony and other proceedings, we don't just assume that she's going to be forthright. And we have a right. She's the star witness of this case.
I may need to know a little bit more about that. in terms of if you want to file something and pound it to me, that's fine.
The final point I'll make, to Your Honor, before you have any other questions.
Was the mega motion not enough? Because it took us something like 15 hours of live coverage to analyze the mega motion. Was that not enough? You need something more in writing? Lawyers, and especially prosecutors and judges, are supposed to avoid even the appearance of impropriety. Just the appearance of impropriety is enough. And this judge is saying, well, what Jennifer McCabe did, by maybe stalking him after the fact doesn't really matter, because all that matters is whether she was intimidated on the date of the alleged intimidation. This is why this statute is never prosecuted in Massachusetts. Okay. This is wild. They don't care. They just do not care. The world is watching. They just don't care. They said, if you're on the Zoom, you're not allowed to broadcast it. That's why we are here doing the Lord's work, because Broken Baker's in Denmark. He's doing the Lord's work. We're restreaming Broken Baker right now. Please give him a like, a sub, and a view. If you have 2 devices, watch it there as well, because we're behind. And this should outrage you as a resident of Massachusetts. All the judges are appointed in Massachusetts. This should outrage you as a constitutionalist, a proceduralist, and anybody who believes in free speech. Cosgrove is going to speak next, I believe. Did Jen buy the judge's sofa? That's a great question. That's a great question. Thank you, Dawn, for making me laugh, because this is outrageous. I'm outraged. Breaking news, Luigi Mangione will not face the death penalty. Okay, here we go.
It's important that we're raising this now. This is well before trial. The prosecution is clearly on notice. I don't know where this may lead to, what else could be discovered. This is a unique case, as you've noted, and evidence is discovered in all kinds of odd ways, believe me, with how these cases proceed and who shares what and those kinds of things. It's critical for us to make this record now, alert the court respectfully.
I have no issue with you making a record.
Because if it comes up later after a jury is impaneled, there is a risk of a mistrial, and that will not be our fault. And we think at that point,
listen, Mr. Federer, I have no issue with you bringing the motion. You need to advocate for your client in any way you think is appropriate. I'm just trying to flesh it out here, so I understand exactly what the issues are. I'm struggling with the relevance issues. You may have to give me more information on that, so I understand it a little bit better, because the way I read things, they're much later in time. Now, if you've got something that's more contemporaneous to the alleged intimidation, I think that's very, very relevant, and would have to sort of play out how that would come in and what the form of that evidence. So we'll come back to that at some point when you're ready to talk to me about that. But talk to me about this. Your motion had 3 parts. Your affidavit had 3 parts, and one was the 2024. That's moot because it's already been done. The second was this issue. The third was this idea that I could preclude the executive branch from investigating things in 2025. Can you give me some authority which says I have the ability to do that?
It's a unique situation, Your Honor. I'm not going to sit here and tell you that there is a case law roadmap to what's happening, but what's important to recognize here, you've been asking us these questions about how is Gaetani relevant. She is extraordinarily relevant to what we're calling the 2025 investigation, which results in these search warrants for the phones of Karen Reed.
Which is still pending with Judge Krupp.
Right.
Let me play that out 2 ways. What if Judge Krupp says he can have access to the phones? Then we're going to have a much longer issue, correct? Is that going to come into this case?
Well, they're telling us that 2 people are under investigation. I mean, it's hard for us to know, right? I mean, they're attempting allegedly to indict Mr. Kearney and Karen Reed for actions in which they already tried to indict and a grand jury said no. And now 2 years later, with phones that have been gathering dust, we need to look in these phones and, God knows what we'll find. But the point is, the search warrants in that case are critical and certainly could relate to evidence used against Mr. Kearney. There are 2 informants in that search warrant. One of them is Lindsay Gaetani. And the affiant of that warrant is Detective Tully. And there are about 10 paragraphs, and I'm paraphrasing, I don't know the exact number.
I read the warrants.
Relying on her and it is loaded with information which she provided them. And we're back to the personal interest of Mr. Cosgrove. So that really was meant to just inform the court that this is a living, breathing issue.
I will agree with you. It's a living, breathing issue. It's just not a living, breathing issue over which I have authority.
Fair enough.
When that comes to me, if it comes to me, I don't know if my special assignment encompasses that. We'll see. But if it comes to me, then we'll deal with that issue. I can find nothing which gives me the authority to restrict that activity. Judge Krupp has the authority on the search warrants, and he'll make a decision in due time. But I find nothing which gives me the authority to restrict prospectively an investigation that's being done by the executive branch.
Judge, just before I sit down, and unless the court has any other questions, I just want to correct one last thing. Your Honor had mentioned about a lawsuit being settled. That is not the lawsuit involving Mr. Cosgrove. There's no...
Sure it is. I looked at the docket this morning.
Not with him. That's with other parties to the litigation, is my understanding.
Okay. Well, let me play this out for you. It's, as I said, I have some familiarity with this immunity issue since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again, an accusation is one thing, but it was...
Hold on. What's a very strong motion to dismiss? Cosgrove's motion to dismiss against Lindsay Gattani? That's not supposed to be a consideration about whether or not you disqualify Cosgrove, whether or not Cosgrove has a conflict. You can't extrapolate and say, well, you know, Lindsay Gattani's lawsuit against Cosgrove probably is not going to succeed. Hold on a minute. I got to take that back and make sure that I am construing this correctly. Well, now I got Proctor up in the corner because he's the root of all evil. Hold on.
I understand.
Well, let me play this out for you.
Your Honor had mentioned about a lawsuit being settled. That is not the lawsuit involving Mr. Cosgrove. There's no...
Sure it is. I looked at the docket this morning.
Not with him. That's with other...
Okay. So Better was talking about the lawsuit between Aidan versus Lindsay that may be being settled. The judge seems to be referring to Lindsay's lawsuit against Cosgrove, Tully, and Michael Morrissey. Right? It's two different things. So let me see what he says here now.
Parties to the litigation is my understanding.
Okay. Well, let me play this out for you. It's, as I said, I have some familiarity with this immunity issue since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again,
So now we're going to talk in hypotheticals? So if Cosgrove files a motion to dismiss Lindsay Gattani's lawsuit, he has immunity. Judge is very familiar with immunity. He'll probably assign himself to hear it anyway. And he'll be like, oh yeah, dismissed. So since I intend to dismiss Lindsay Gattani's lawsuit anyway, because I'm very familiar with those kind of cases, she's got a frivolous lawsuit. It's not going to succeed. Right. The conflict being settled doesn't erase the fact that a conflict existed. Right. This is, I can't emphasize to you enough how insane this is. And I know that if my friend Mark Betterow was sitting here with me, like he often did during the Karen Reed trials, he would, and I can tell just by his tone that we are all right there in the land of the lost. The fix is in. This is Judge Belezos.
accusation is one thing, but it would seem like there's a little bit more. You'd have to have some substance to it to actually disqualify. But I'll keep an open mind on it.
You know what else? You know what else you would have to have? You would have to have some substance on charges of witness intimidation to indict a man on, I don't know how many are left. I think there were 16 felony charges initially against him. You should actually have to have some evidence for that before you put him through however many years this has been going on for, since at least 2023, right? The rolling rally, July 2023. He said the first charges against JenMcCabe were in June 22, 2.5, almost 3 years. This has been going on for Aidan Kearney. You know what would be good? If you had some actual evidence to bring those charges. But here you are, an appointed official, telling the world that Lindsay Gattani's case is probably going to get thrown out. But we had enough evidence to charge this man, a journalist, with 16 felony counts of witness intimidation because he yelled from a bullhorn and said, "Tell the truth." Wow. Are you effing kidding me?
But it would seem like there's a little bit more. You'd have to have some substance to it to actually.
And you should have some substance to your criminal charges when you're charging a man with 16 felonies that each count could, under the statute, there's not 16 remaining, a bunch were dismissed, 10 years on each charge. Those have no substance, in my opinion.
Disqualifying, but I'll keep an open mind on it. Anything more?
Anything else?
No, I read all your stuff.
Thank you.
Anything more?
No, sir.
Mr. Bradley, anything?
No, Judge, thank you.
Okay. Mr. Kearney, Mr. Cosgrove, if not, if you're conflicted out in one case, why aren't you conflicted out on the other? That's the real big question here.
Well, I don't think the two necessarily follow, Your Honor. Obviously, before I filed my motion seeking to withdraw in the other case, I would have been a poor attorney indeed if I didn't think about whether it also required me to withdraw in this case.
It's debatable.
And the motion to withdraw was, at least I attempted to phrase it quite carefully, to say that I had a conflict because Ms. Kearney was the alleged victim in that case. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts. But nevertheless, it was essentially an argument that I would be making in that case, that Mr. Kearney committed crimes against Ms. Kearney. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Kearney's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if it came to trial?
Well, that's a very interesting point, Your Honor. And there's a couple of problems with it. One problem is the practical matter. I don't see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt the defense.
Okay, if you're new and you're just coming in, the reason that it's so blown out, the video, is because it's a Zoom feed. That's all we have. This is insane. Howie Carr calls Cosgrove, triple dip Cosgrove for a reason. He's getting a pension from being a judge and another pension, and now he's billing by the hour for this bullshit. And here's the bullshit button. We're gonna have the chance to see some more corruption at 2 p.m. when we go to the Alex Green bail hearing with Judge Cannoni. I'm taking this back a moment. I mean, I don't know why I am. This is so clear as day to me and anybody else who really actually practices law, and that this judge is doing cartwheels and twisting himself into a pretzel. He's like a contortionist to try and make this Cosgrove not conflicted, because you know why? They're not going to find anybody else. They're not going to find anybody else to prosecute Aidan Kearney. Cosgrove should not just be conflicted, but Michael Morrissey's entire office is already conflicted. That is the reason that they had to hire special prosecutor Robert Cosgrove. And remember that affidavit that he submitted in the voice of Ken Mello. Remember, he's like, oh, well, I can't reach Ken Mello to sign this, so now I'm going to do the voice of Ken Mello. And he went on for pages in the voice of Ken Mello. In order to find somebody else to prosecute, they would have to go to another county and get it. And nobody else is going to touch this thing with a 5 million foot pole. Okay. Okay. Let's hear this again.
Atty making represents the Commonwealth, and the Commonwealth is but that she was the alleged victim. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts.
Wow, you know what's so interesting about that is that all these alleged victims in other cases are getting such special treatment, aren't they? From the Commonwealth and the victim witness advocate and special information and inside information and what's happening in the grand jury and when the grand jury is going to be over. But you don't represent them, right? You can't use it as a shield and a sword. You can't say, well, here, I don't represent Lindsay Gattani. You know, she's just a victim. I represent the people of the Commonwealth of Massachusetts. And then turn around and say, well, I represent all of the witnesses because I'm Michael Morrissey and I'm issuing a hostage video on behalf of all of the victims of witness intimidation. This needs to stop. Colin Albert was not in the house. Michael Proctor never went to fair. I thought you represent the Commonwealth, the people of Massachusetts. Then why do you get on there and do hostage videos as if you are representing all of the witnesses and victims, right? It is, you cannot use it as a shield and a sword. And if this judge knows as much as he thinks that he does about everything else going on in Massachusetts, then he should know exactly what happened in the Karen Reed case. And this is the reason Aidan Kearney is sitting here, and I am outraged. All the calls and emails to Cosgrove, right? And Kate Peter working on behalf of, you know, giving Tully information. This is insane.
But nevertheless, it was essentially an argument that I would be making in that case, that Mr. Kearney committed crimes against Ms. Gattani. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Gattani's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if it came to trial?
It's obvious.
Well, that's a very interesting point, Your Honor.
That's what somebody says when they're stalling for time. First of all, we have word salad emojis for members. We've got handcuff emojis. Use them all because they're relevant here. And this is a Zoom camera. So, of course, it's not pointing at, you know, Cosgrove. We can't see him speak.
There's a couple of problems with it. One problem is the practical matter.
You can't see
I don't
Cosgrove.
see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt the defense theory that everything is relevant to every issue, but I don't see how indicating that Ms. Gattani was not credible in making statements about the investigation of Mr. Kearney here would have any relevance to an accusation that I breached some sort of duty to her by turning over a police report, which is the contention. Also, Your Honor, assuming that this even survives a motion to dismiss, and I'm talking now about the Middlesex case, I don't think there's any
Worcester
factual dispute.
Worcester case, there's nothing in Middlesex, right?
I'm sorry, Worcester, yes,
Okay,
thank you,
all right.
I appreciate the correction.
Oh, he does know
I
everything
don't
about
think
the
there's
case.
any factual dispute as to what happened. In my capacity as a prosecutor, I provided Mr. Bradel with the police report in question as discovery. It made its way by whatever means from Mr. Bradel to Mr. Kearney, who then publicized details of it and turned it over to a friend, an associate, whatever you want to call him, who actually put the whole report, as I understand it, on the internet and began pillaring Ms. Kearney over her credibility. I don't dispute that I turned that report over as a matter of discovery. If this case ever develops in Middlesex and comes to fruition, I couldn't possibly dispute that. That's the absolute factual truth. From that point on, it becomes a pure question of law as to whether I breached some sort of duty under the statute to Ms. Kearney under the mistaken belief that I had a Rule 14 obligation to turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias. Maybe I made a mistake. Maybe I was wrong legally. But that's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter.
How do we avoid the circumstance that she's called to the stand and there's some relevant testimony that she can offer? You wouldn't call her, but the defense calls her. And you're in the midst of cross-examining her and she says, well, this is why I sued you. What do we do with that?
I'm not sure what you do with it, Your Honor. Maybe we deal with that with the motion in limine to preclude her from mentioning the Middlesex suit.
Doesn't sound like a terribly controllable witness.
Well, that's why we have skillful Superior Court judges, Your Honor. If I could
You can find one.
be a little obviously self-serving in my comment. I'm sure, Your Honor, both in his...
Did the judge just say, if you could find one? Hold on. Sorry, there's no captions, but we can't do captions on live. If you don't think that they would go through anything, they will go to every single length possible to incarcerate Aidan Kearney, you would be wrong. This is why he needs your support, because this is the First Amendment on trial here. This is freedom of the press on trial here, and this is outrageous. I don't know. Let's hear that again. Thank you. Thanks, Bob Mata. Here is the conflict in black and white. I'm not insane, right? I might be insane, but not with regard to this issue.
Her from mentioning what you do with it, Your Honor. I'm not sure what you do with it, Your Honor.
Look at Pedro's reaction.
Maybe we deal with that with the motion in limine to preclude her from mentioning the Middlesex suit.
Doesn't sound like a terribly controllable witness.
Well,
doesn't sound like it's hardly a controllable witness. Did he just say that? Is he calling Lindsay Gattani uncontrollable? Is she a typical hysterical woman? She's uncontrollable? Hold on a second. They've already slut-shamed her in their papers. They have already disparaged her publicly in their papers. And now the judge is saying she's an uncontrollable witness. I think that's what he said. Did I hear him wrong? Hold on. Like a motion in limine for her not to say stuff isn't going to
That's
work.
why
It's
we-
just uncontrollable.
Maybe we deal with that with the motion in limine to preclude her from mentioning the Middlesex suit.
Doesn't sound like a terribly controllable witness.
Wow, doesn't sound like a terribly controllable witness. Wow. This is an episode of The Handmaid's Tale. This is an episode of The Handmaid's Tale, and it's the Truman Show, and it's a big joke, and we're all in on the same joke. We are all in on the same joke. How about you just disqualify him, then it's not an issue, and then somebody else has to find somebody else to come in and persecute Aidan Kearney, journalist. How about that?
That's why we have skillful Superior Court judges, Your Honor, if I could
If you can find one, that's
be a little obviously self-serving in my...
If you could find one, he said, if you could find one, a skillful Superior Court judge. This is a joke. The world is watching, although they didn't want the world to watch, under his eye. Thanks, Bob.
my comment. I'm sure, Your Honor, both in his prior career, as I have in mine, and in your present position, has dealt with witnesses that are difficult to control.
What about the possibility of someone else coming in? Is that something that's realistic or not realistic?
I didn't quite hear you. Something else?
What about the possibility of bringing someone in to deal with Miss Gaetano if indeed she's a witness?
No, he has to be recused from the whole case. You can't just recuse him or disqualify him from questioning one witness. That is not the way this works. Hello?
Could be done.
Well, it would solve a lot of issues.
No. Belezos' head is going to
Mr. Belezos?
explode.
I mean, you're not contending that the case.
No.
Well, it would solve a lot of issues. Mr. Belezos? I mean, you're not contending that the case goes away completely. You're contending that he can't deal with Gaetano.
Unless, Your Honor, I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani. But if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard-pressed to figure out why the issue of the lawsuit would come out.
It doesn't matter.
I don't know.
But that is my job to control what comes out. But
It doesn't matter if it comes out or not. Okay. Whether it comes out in court or not, that she is suing him does not absolve him of the conflict of interest as an attorney for the people of the Commonwealth of Massachusetts. It doesn't matter. It's still a conflict. I just can't. I just can't with this.
so
Yes.
Legally, let's think about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think we all agree.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure it out. I guess the first question is, why are we having this conversation, and why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we're having this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove...
I think he's not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. So
Cosgrove has barely started. He's talking about himself in the third person. Okay. Jimmy's getting upset. George is getting upset. He's talking about himself in the third person, just the way that he used Mello's voice. Listen.
conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove...
I think he's not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. So
Cosgrove has barely started.
it would appear to me what you're saying to me is if there was a replacement for that issue, that would resolve this problem.
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility of Ms.
You'd
Gaetani.
agree with me that does happen in trials, not with some frequency, but it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a statement of a defendant.
Sure.
They have to be a witness, I mean, these kinds of things can happen all the time.
We find ways around them.
But we're also, to be clear, we're dealing with a very rare situation where the witness is a former prosecution witness accusing the prosecutor who she testified for previously of misconduct. Now, if the prosecution and the court approves of that process, wants to have that laid bare, then I suppose it could. But the other problem,
just on this issue, we're not going to hijack the rest of the argument.
Okay,
just on the issue of replacement.
I had a brief response.
Yeah, he's not done. You only get to respond when he's done.
Yes.
Mr. Cosgrove.
Well, just on that point, I have yet to hear how any comment that I might make on the credibility of Ms. Gaetani's testimony in the case before the court would even come in or be relevant in the Middlesex case or assist me in any way. Am I going to go over to Middlesex Superior Court and, frankly, I find it hard to believe that I or whoever would be representing me would be brazen enough to say to the judge, well, I want to talk about all the ways in which my client, Mr. Cosgrove, impeached Ms. Gaetani in a case that has nothing whatsoever to do with the case before the court. There's just not going to be any bleed through whatsoever, it seems to me. We don't even have, frankly, Ms. Gaetani's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that either the Commonwealth or the defense is going to call her in this case.
Well, you certainly thought she was credible when you incarcerated him. You certainly thought, the Commonwealth, certainly found Lindsay Gaetani credible when you chose to incarcerate him for 60 days. Again, shield and sword. I highly doubt anyone's going to call her because she has zero credibility. It was enough credibility to incarcerate him. Taking it back a second because I still can't believe this is happening. They are going to do everything they can to bankrupt this man. They will do everything they can to bankrupt him and incarcerate him. And his defense fund is in the show notes below this video, if you choose to donate.
Frankly, Ms. Gaetani's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that either the Commonwealth or the defense is going to call her.
Oh, the defense is going to call her.
Mr. Counsel has carefully said we may call her for the defense.
Carefully.
This may be a contingency that doesn't even arise, but that's sort of a side point. Let me just take a couple of points. I was going to ask Your Honor to take judicial notice of the pleadings in the Middlesex case and the docket. It appears you've effectively done that, but let me make an oral motion on the record.
Any objection, Counsel?
No. Purpose.
Okay. Agreement. I'll take those as judicial notice as to the Worcester Superior Court case.
And one of the interesting, unique things about this alleged conflict of interest, which is a little different from the typical conflict of interest case, at least I haven't found anything precisely on point, and I don't think the defense has either, but maybe they'll prove me wrong in a moment, is the whole operation by which this alleged conflict has come about and the Middlesex case has come about what is it that enables Ms. Kearney to make the claim that she's seeking to make against me in the Middlesex case? It's that defendant took the report I gave him as discovery, or I gave his counsel as discovery in the other case, publicized it, and then created the harm that Ms. Kearney alleges accrued to her from that publication. In other words, if we're...
He's talking about the publication of Lindsay Gattani's total phone extraction, that he's saying it's Aidan Kearney's fault because he gave it to somebody who published it. So that's his argument.
Applying but-for causation, to sound like a tort lawyer for a minute, if we take Mr. Kearney's actions out of the whole proceeding, there's no harm whatsoever to Ms. Kearney with my, as I see it, fulfilling my Rule 14 obligation. So Your Honor has the unusual situation here of a defendant who has been but for cause of the alleged conflict, seeking to profit from that conflict by removing the prosecutor of his case, which I think is
Torsion City.
is worth some consideration by the court. What I would like to do now, Your Honor, since the defendant has had the opportunity for a reply brief, which frankly doesn't particularly go to these motions, particularly, but more to the point, the defendant's reply in support of the motion to disqualify Robert Cosgrove. I'd like to examine that in some detail and take the opportunity to reply to some of his.
Well, it really hasn't become an issue here. That involves another party whose case has been dismissed. The case regarding the defendant and that witness is gone. That's dismissed. So I don't really know if that's all that relevant to any. Mr. Beddoe didn't even raise it.
For purposes of this, Your Honor, the briefs are what they are. We submitted them. I just raised the issues I thought would be helpful for the court today.
Yeah, I didn't find that anything with regard to that particular trooper terribly compelling because I don't understand how he would be part of this case. Fair to say?
You're talking about which trooper?
The trooper whose case was dismissed, Bouchard.
I'm not talking about the, I'm sorry for interrupting, Your Honor. I'm not talking about the motion that they filed with respect to discovery for Mr. Proctor.
Oh, I'm not dealing with discovery right now. Yeah.
I'm talking about the motion that's captioned, Sir reply in support of motion to disqualify Robert Cosgrove.
Paper 127 you're talking about.
I don't know the number, to be honest with you, but
Wow. It's 5 o'clock somewhere, Kyle.
This one here?
yes,
Yep,
exactly.
that's 127.
Okay.
Okay, go on, I'll hear you.
All right. So, the defense begins by complaining that my response envisions my conflict in a vacuum, and that it ignores the whole context, which is basically a preface, Your Honor, for talking about everything else that the defense is unhappy with about the case, except issues that are relevant to whether or not I should be disqualified. There is, on page 1 of that motion, a suggestion that Mr. Morrissey recused his office from prosecuting Mr. Kearney due to a conflict created by an investigating journalist who publicly accused the DA's office. I'm not sure that Mr. Morrissey has made a statement explaining why he appointed a special prosecutor, but I'm ready to stand to be corrected, but certainly this is the explanation that might found most favorable to the defendant, but what does it have to do with disqualifying me? He then talks about accusations against Lieutenant Tully and former Trooper Proctor and Sergeant Uri Buchanan. What does that have to do with disqualifying me? He talks about actions by Sergeant Buchanan taken after he left the Norfolk District Attorney's Office in support of a legal civil dispute between Ms. Reed and the alleged victims in this case. That has nothing to do with whether I should be disqualified. We've talked about my voluntary withdrawal from the indictments concerning Ms. Gattani. And if Your Honor would take a look at page 6, where we have bullet points. All right. The first bullet point is absolutely relevant, and that's what we've talked about, that I'm being sued for intentional misconduct by Ms. Gattani. And we hear that Lieutenant Tully is being sued by Ms. Gattani. So what? The Detective Tully has been sued by Karen Reed. What's that got to do with it?
So what? So what? We're all corrupt. So what? Not one interruption, right, Kim? Not one interruption. B-Max, we'll take any and all prayers for my 4-month-old nephew. Just got through his 3rd round of chemo. Prayers up. So sorry to hear that. So what? He said. Taking it back.
By Ms. Gattani. So what? The Detective Tully has been sued by Karen Reed. What's that got to do with the price of beans, as they say?
All the beans.
There were disciplinary proceedings against Lieutenant Tully.
That might be relevant on cross, you'd agree?
Oh, yeah, it might have some relevance on cross, but what has it to do with disqualifying me, Your Honor? They weren't disciplinary proceedings
Fair point.
against me.
Okay, you don't need to have disciplinary proceedings against you to be disqualified. Are we on the same planet? This is Robert Cosgrove, special prosecutor Robert Cosgrove speaking. The Zoom camera does not have him in frame, of course. His picture's on the thumbnail of this video. And he cannot seem to learn how to pronounce Aidan Kearney's name. Is he still saying Kearney? Friend of Dog, thank you for gifting 10 memberships. You're amazing. We'll get to the super chats after. Thank you so much. Gigi is here. She gifted 10 memberships too. All the new members, you have emojis to use at your pleasure. Here we go.
We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed, but what has it to do to disqualifying me in this case?
Did you hear the way he said Ms. Reed with such contempt? Ms. Reed is suing Buchanan. Ms. Reed, did you hear that? They don't even try and hide their bias anymore. They don't even try and hide it. It's not even like they're the worst actors in the world. Listen to this. Good luck to Ms. Reed. We all know she's never going to get anywhere in the Commonwealth of Massachusetts.
We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed, but what has it to do to disqualifying me in this case? We hear that Buchanan was disciplined. That Proctor has been sued by Ms. Reed. That Proctor has had disparaging text about Ms. Reed.
So what?
There are two things that the upcoming case should not be about, Your Honor, and I'm sorry I'm losing my voice here, excuse me. One, it should not be a trial of the case that has been null pros concerning Ms. Gattani. And two, it should not be a retrial of the Karen Reed case. None of this stuff is relevant.
The reason this man is on trial is because he was outspoken on the Karen Reed case. They are not disconnected, sir. They are completely intertwined. Bias, corruption. The reason that you were hired, sir, counselor, my brother, is because Michael Marcy had a conflict. That's the reason you were hired. Everything is intertwined.
Attorney's testimony will undermine the credibility of Detective Lieutenant Tully and Ms. McCabe, which will subject her to cross-examination by Mr. Cosgrove. Now, let's look specifically, if I can skip ahead in the memorandum. The argument that's been made a little later on in the memorandum, in which Your Honor has heard again today. And I'm looking now at page 16, Your Honor, the first full paragraph. Ms. Gattani will testify that Detective Lieutenant Tully intentionally mishandled her cell phone by tampering with and or deleting its contents. Detective Lieutenant Tully will deny this. Mr. Cosgrove has accepted Detective Lieutenant Tully's explanation without any further investigation. Well, I don't know how the defense knows that I've accepted Detective Lieutenant Tully's explanation without any further investigation. But let's put this on a timeline.
It's a circus, James.
It has been the contention of the defense from the start of the case that certain items were missing from the download of Ms. Gattani's cell phone. And their explanation is that must be because Detective Lieutenant Tully deleted it.
Spoiler alert. He did. He did. Do you want this on higher speed? I can put it on higher speed, I think. He does talk at a snail's pace. Let's try and just do it at 135. We'll try 135.
I responded to that.
Oh, there's Bradle.
Ms. Gattani is a latecomer to this discussion. She is only now, in the form of either public statements or representations by the defense as to her new position, suggested that this is because Detective Lieutenant Tully tampered with it or deleted its contents. By the way, I don't know how she would know that because she was not there during the download of her cell phone and the transfer of it. But at any rate,
wasn't he the only one that had possession of her phone? Anyone, Bueller, anyone?
My response as to what happened to the cell phone occurred before Ms. Gattani made any of these statements whatsoever. I don't know how it can be that I have been siding with Detective Lieutenant Tully over Ms. Gattani. I haven't seen an affidavit from Ms. Gattani. I haven't seen anything from Ms. Gattani other than hearsay, which is just a representation. And certainly, but let's assume that I do, as they put it, side with Detective Lieutenant Tully in cross-examining Ms. Gattani and in the closing argument. What does that have to do with defending my position in the Middlesex case, and how is it relevant, and how would it even be introduced? I have no idea.
It doesn't
matter. Let me back
matter.
up and make a couple of other points.
A conflict is a conflict. Maybe this happens, maybe that happens, maybe we don't call her, maybe they don't call her. It doesn't, a conflict is a conflict. This is not a hypothetical thing. Okay? It's not hypothetical. It's pretty black and white right here.
I want to turn to the legal argument, say a little bit about the law. And I suspect Your Honor has probably already looked at the two cases cited by Mr. Betterow, Commonwealth versus Dunlap.
Notice how he doesn't interrupt Cosgrove at all. He only interrupts Betterow because he's already mad at Betterow. He spanked him when he came in about his affidavit. It's not how we do things in Massachusetts, Mr. Betterow.
The other case is named USD Health, which involves a complicated civil action involving the Church of Scientology and others. The first thing to say about these cases is they're Pennsylvania cases, not Massachusetts cases. So at best, I would say they are persuasive authority, not binding authority.
I don't think Ms. Betterow contests otherwise.
The second thing I would say is that they are both opinions in which the court declined to rule for the defense on the conflict of interest argument. In the first case, Dunlap, the decision of the Superior Court judge was affirmed by an equally divided court.
Here's the judge if you want to see what he looks like.
Dissenting justices characterize the other side as the majority, but the opinion itself says that the appellate court was equally divided. So I'm not sure if it's even good as dicta. It seems to me it has no precedential value at all, but if it does have precedential value, it was a ruling in favor of the Commonwealth. And what were the facts? In a sentence from the dissent, that is, those who believe there was a conflict of interest, the district attorney who prosecuted this case also represented the victim in a civil suit arising out of the same transaction. That is a mile away. That is a stadium away. That is a continent away from the facts in this case. I am certainly not representing Ms. Kearney in a civil suit arising out of the events that bring the defendant into court. Now let's take a look at USD Health, I guess it is, which is the federal case. That does have some interesting parallels to this case. According to the decision, and I apologize for not having the pin sites, but I think Your Honor will readily find them, the defendants contended on appeal that they were denied due process because two prosecutors were defendants in a civil action filed by the Church of Scientology 10 days after the events that went down in this particular case. And they alleged, and the events that went down were a search of the Scientology's office in Los Angeles, and they alleged that the raids were conducted in bad faith with the intention of violating.
No, it's Los Angeles. The Church of Scientology. He's talking about a different case. He's talking about a case that he thinks applies here involving the Church of Scientology. I know your minds have started to wander. You're hearing wah, 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 wah. This is Special Prosecutor Triple Dip Robert Cosgrove in action. We've put him on 1.5 speed.
Scientology's constitutional rights. You can look back at the memos filed by the defense, and the contention they're trying to make, well, one of them is that this is a bad faith prosecution. So that applies here. What is different here is the civil suit apparently precedes the raid that the prosecutors make in the defense office, the Church of Scientology. Here, there's nothing like that. The events that the defendant was charged with in this case occur before any involvement by Ms. Kearney, before any involvement, by that matter, with me. And those issues are pretty well set and have consistently been followed through. Now, here's another similarity between Height and the current case. I'll just read a sentence or two. The government contends that prosecutors cannot be disqualified when sued by a defendant because defendants could then remove whichever prosecutor they please simply by suing him. Now, of course, the defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential.
He's seeking to profit by a witness suing you? Aidan Kearney is seeking to profit from a witness suing you. Did he tell her to file that lawsuit? This is insane. How does the judge allow him to keep going with his bullshit? You should be outraged if you're not already. Tell me if you're outraged. Listen to this again.
Now, of course, the defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential conflict. I have not gone so far as to represent to the court that I cannot be disqualified when sued by a defendant or by Ms. Gattani. I think in fairness, the court can look at it. But the federal court, the argument was that any suit complaining of an action taken in the prosecutor's quasi-judicial capacity would be frivolous and non-disqualifying because he enjoys absolute immunity as a prosecutor. Cite to a U.S. Supreme Court case. I believe as Your Honor reads through, we'll find that the court in Height pretty much bought that argument. And they go on to say that appellants have made no credible claim of actual prejudice based on the prosecutor's alleged pecuniary or personal interest in the outcome of this prosecution. I certainly have no pecuniary interest in the outcome of this prosecution. I have no personal interest in the outcome of this prosecution. And nothing in this prosecution is going to affect anything that's going on in Middlesex.
It's not Middlesex.
Worcester Superior Court, Your Honor.
Understood. Anything further? From Mr. Cosgrove, sorry.
No, I'll stop at that point, Your Honor.
Mr. Bedrow.
Yes, thank you, Your Honor. We might as well start from the back with U.S. v. Help, Your Honor, which is 668 Federal 2nd, 1238, the D.C. Circuit, 1981. Mr. Cosgrove has buried the lead about Help and about Dunlop. Those were appellate arguments post-conviction. That is a huge distinction about a timely motion in advance, raising issues which could lead to a conflict. We all know that raising a conflict on appeal when you could have raised it before is looked at in an entirely different way. And the relevant language from Help that I would direct the court to is on page 1276, which states, given the need to promote the appearance of justice, a trial court on timely motion to wit, like here, should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. That's here.
Well, the key words are alleging bad faith. I'm not sure that there's an allegation in those other complaints of bad faith. There's an allegation he violated the statute. I'm not sure where it talks about bad faith.
Sued him for intentional infliction of emotional distress.
Negligent infliction. There's a difference.
She sued for intentional.
I read negligent, but I'll go on.
Respectfully, Your Honor, there are deliberate allegations of intentional misconduct in the complaint, but that's, the court can obviously go back and one of us.
We took judicial notice.
Exactly.
So
one of us is right.
I read this morning as negligent, but
Dunlop is the same situation, Your Honor. It's post-conviction. The other issue, and I want to now go back to the beginning that Mr. Cosgrove started with, he illustrates the whole problem here. He's defending himself, and I have no opinion on the merits of Ms. Gattani's claim, okay? As a lawyer, I sympathize. But he started by telling you that this case is going to get dismissed, and all I did was turn over this. He is illustrating front and center his personal interest that Gattani is accusing him of things he didn't do. And the conflict, the personal interest.
We're gonna go back to regular speed for Betterow because he speaks fast anyway. But if there's one thing Mark Betterow knows, it's case law. Don't mess with him when he's talking about case law. Okay? All right, come on, let's go back to normal. Normal. He's defending himself. That's exactly what he's doing. It's not, he's defending himself, Cosgrove. That proves that he has a conflict. Otherwise, he wouldn't feel the need to defend himself. Right? Of course, right.
The outcome.
She's not accusing things he didn't do. He acknowledges doing.
But he's justifying it and saying she's trying to do this. She's not credible. The point is this. The personal interest for Mr. Cosgrove is not whether he was wrongfully sued or whether it has any merit. His good name has been attacked. And like anyone else, he has an absolute right and a personal interest in defending himself. And again, the proper forum to do that is not while prosecuting a case in which his accuser is a witness, his co-defendant is a witness, and Ms. Gattani is going to probably impeach, assuming she's allowed to, their star witness, Ms. McCabe. When someone's integrity is attacked, they have a personal interest, especially someone as credentialed and respected as Mr. Cosgrove. We all understand that as lawyers and judges, but that doesn't mean you get to prosecute the case. That's for you to decide, obviously. And we're talking about an appearance. This looks terrible, which leads to my next point. Mr. Cosgrove went through all of these allegations in our papers about, Proctor had this, Tully's been sanctioned, Buchanan, it's literally aligned with JenMcCabe, which we wrote about, supporting her. Buchanan was a witness in this case too, and part of the investigation.
But not anymore.
No, but the point is this.
No, because he's been
looking at this
fired.
in a vacuum. The public must have.
For the love of the traveling, he's been fired. This is on normal speed. Hold on.
It's literally aligned with JenMcCabe, which we wrote about, supporting her. Buchanan was a witness in this case too, and part of the investigation.
But not anymore.
No, but the point is this. He is looking at this in a vacuum. The public.
Buchanan, not anymore, because the Lindsay Gattani charges were dismissed. He wasn't talking about Proctor. He was talking about Buchanan. And he's also Buchanan's, the charges, I'm sorry, I misspoke. The charges, the witness intimidation charges against Buchanan have been dismissed. So he's no longer a witness because he's no longer intimidated, because that was thrown out. Those are one of the charges against Aidan that got thrown out. The charges against Proctor got thrown out. The charges against Buchanan got thrown out.
Must have confidence. Part of the analysis of a conflict of interest is the first sentence of the brief that he just cited from, is that the public must have confidence in the criminal justice system. And this latest conflict is a pile on conflict after conflict after conflict in this case. And if the cherry on the sundae...
But let me slow you down, because we're conflating two different issues. I'll agree with you. There's all sorts of issues that have developed over the course of these interrelated prosecutions. Mr. Cosgrove's role, though, is a latecomer and really had nothing to do with any of these other issues. So I can't sit and say I impute all of those other things to Mr. Cosgrove. And therefore, if we look at that mass of problems that have developed, he's out. Because the same logic would say the next person who sits in that seat, the same argument would apply.
Let me be very clear. I'm not accusing.
I didn't take it that you were.
Fair enough.
But my point is, all of those things are conditions which are already present in this prosecution.
They are.
So really, the only thing that I'm dealing with is this one issue, because the rest of those things he had nothing to do with.
Well, one of them, he had this other conflict which he voluntarily sought.
But that came out of the same exact issue.
Yes. Well, that's our point. We think it's the same conflict.
I agree with you. But what I'm trying to, the point I'm trying to draw and the distinction is, all of these other problems that arose out of the Reed prosecution, real, imagined, substantial, that's really not for me to decide, right? They're all out there, all right? And they're all going to be there no matter what. So whoever sits in that chair right there is going to have all of those problems.
Difference, I don't mean to cut you off, Your Honor.
Yeah.
The difference is that if it's not Mr. Cosgrove, the man who or woman who would be sitting in that chair is not being sued by Ms. Gaetani and co-defendants with DL Tully.
That's my point. Right. That's the only thing I have to analyze. Okay. That point.
Our point, respectfully, was that given the public's need for confidence in this case, not the Karen Reed case, that's a whole nother conversation for someone else on another day. But this case is filled with conflicts, and I don't think we can all just avert our eyes to and say, but none of that matters, but we're going to have a prosecutor now cross-examine his accuser and then say she's not credible. He also indicated, Your Honor, they're not even calling Ms. Gaetani. I can't fathom how that might happen. They use careful language. They may call her. We're the defense. We don't have to do anything. We can take a nap throughout this trial.
Yes.
And there may be such a terrible joke of a case they present that we stand up and rest. So, of course, why would any credible, serious lawyer commit a year in advance, I'm calling this witness? We're alerting Mr. Cosgrove to what we think is his conflict and the court, and we may very well do that. the last point for this, you know, he said there's no affidavit from Ms. Gaetani, or it's all just hearsay about, you know, tampering with her phone. The best basis for that will be the posting online social media by a third party and long-time known critic of Mr. Kearney of messages which did not appear on an extraction report that we got from Tully of Gaetani's phone, and then we never got anything from Tully's phone. We got screenshots of what he claimed were messages. That's the basis for that. Thank you.
Okay, fair enough. All right, so here's what we'll do. We're going to set another date.
Kick the can down the road.
Let me talk about this. Mr. Brady, when we selected we penciled in the trial date, I gave you a very long date, longer than I wanted. Your schedule, has it changed? Can we get this thing done earlier? Assuming it's alive?
Judge, it's probably gotten worse.
All right, well, we're not moving the case back. That trial date's not going to go backwards.
Okay.
This is a 2023 case. It's 2026. It's not going backwards. If anything, it's going to move forward. So don't.
I know you'll relate to this, Judge. I have the usual
I
slate
know.
of like fall murder cases.
I get it. But this one's an old one, and it's set. So I was going to try to move you forward. But if you tell me that can't happen, then that can't happen.
I'm sorry.
All right, but understood. This court is willing to take this case much faster than the current schedule.
We do have a few other pretrial matters to address. Your Honor mentioned the motion to dismiss. Maybe we should schedule that.
What we're gonna do is this. I'm gonna take this under advisement. We're gonna pick a date right now. And either we do a motion to dismiss that day, or we're on for appearance of new counsel that day. All right, one or the other. We're gonna know. I'll get your decision beforehand. Now, I am open to the idea that if I accept there's a conflict here, I haven't made that determination yet, but if I accept there's a conflict, I'm open to the idea that it's resolvable by having someone else step in and cross-examine.
It's not.
I think that solves all of the issues. So that might be the easy way here, so everybody can get this thing moving and have this trial.
How would it be? They would be co-counsel. How would it be? How would it resolve the conflict to have one new lawyer come in to question Lindsay Gaetani? It doesn't.
Trial, which all parties seem to desire.
So just on that point, I appreciate you kind of reflecting your thought process. But, you know, even if counsel stays on the case, but doesn't actually do the questioning, it still remains that there's a conflicted counsel on the case.
Thank you.
And the
Mr.
jury
Bradley,
ought to know
you and I both know
of that interest.
Mr. Bradley, you and I both know this happens with some frequency, and we work our way around. All right. The jury's concentration in this case is on the events of the case. Now, Ms. McCabe's credibility, I expect to be a robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But Mr. Cosgrove raises a reasonably good point.
No, he doesn't.
That, you know, there's been some recent case law talking about, you know, the police can't create their own exigency. And to some extent, the defendant has created his own exigency here. Because in fact,
he's not the police.
The plaintiff in that case is suing.
The defendant is not the police. Law enforcement is held to a different standard than a civilian. Is my head in Connecticut yet? Did somebody get it at the ferry? New London? Anyone? Listen to that again.
Exigency.
So they could have created some exigency 4 years ago yesterday when they decided that they could search the house, maybe for some evidence of murder or evidence of a fight or where's the dog. They didn't even think it was even going to be possible to search that house. This is insane. I can't explain to you how insane this is. Listen to this again.
All the information that you've gathered and robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But Mr. Cosgrove raises a reasonably good point. that, there's been some recent case law talking about, the police can't create their own exigency. And to some extent, the defendant has created his own exigency here. Because in fact, the plaintiff in that case is suing because the contents of her phone were put on the internet. The defendant did that. So there is some...
Well, you seem to know a lot about the civil suit between Aidan and Lindsay. Tully is the one who released the entire phone extraction to the defendants. That's a Tully problem. That's not an Aidan problem. And he didn't release it. Jason Broyles did. Thank you. So the judge is making all kinds of assumptions about what happened here when those of you who have been paying attention have been paying attention here. And you know more than this judge does. Okay? Judge Belezos. His name is scrolling along the bottom of your screen. It's probably really tiny, so you probably can't read it.
And the defendant has created his own exigency here. Because in fact, the plaintiff in that case is suing because the contents of her phone were put on the internet. The defendant did that. So there is some, you got to be fair to both sides here and say this is something which only happened because of steps taken by the defendant.
Well, Judge, I don't want our lack of response to that to be perceived as an acknowledgement. I don't want to address that.
I'm basing that simply. I'm basing that simply on what I read in her complaint, not on anything that's been represented to me today.
Right, exactly. And so, just a couple rewinds here, judges. That the government themselves, in Lieutenant Tully's own affidavit at the time of this, back in December of 23, swore in the affidavit that Ms. Gattani was a witness in the matter. And so I don't think the government can do a 180 and say, oh, right, she's not really a witness.
Right.
Oh, she's a witness, but she was a witness at that point. They were trying to indict your client.
Kidding me?
For some sort of conspiracy charge, which failed.
Sir, no, sir. No, sir. She was served with a grand jury subpoena to testify in the 2023 case involving the McCabes and the Alberts. Okay? Not for the witness, not for that other case to which you refer, that they did not indict the ham sandwich. Okay? If you look at the contents of that subpoena, it is for the 2023 case involving the McCabes and the Alberts. Again, you can't use it as a shield and a sword and twist the facts, contortionist, to get yourself into a pretzel to say that Cosgrove doesn't have a conflict. Wow. See what Bradel says. He knows the facts.
Right.
All right. And
apparently
the grand jury didn't
live and under investigation.
Well, that's another matter.
It's not right.
I've told you I have no authority to affect that. What I do know is that was no build.
No build.
Even worse. Okay. That was no build.
Even worse.
I can't imagine a circumstance where I would allow evidence in about a no build issue. I remain to be persuaded on that. But
so what? And just to go to the lowest hanging fruit on why Ms. Gattani would be a witness, there's all sorts of screenshots and text messages, and we need these things authenticated before we use them.
I'm not necessarily saying that can't happen.
There's all sorts of reasons.
I get that, but
no one's trying to trigger a recusal. There's a lot of good reasons why she's involved in this. The government's own affidavit.
I'm not discrediting what you're saying. What I'm saying to you is, I think there's a way around this. And I don't know that a closing argument is going to change that, because the closing argument is based on what's heard at the trial, and I'd add, in this court's view, and in the proper practice, would be confined strictly to the evidence that's presented before the court. So, no, it's not going to.
I appreciate your reflections, Judge. If I could just have one moment.
Yeah.
He knows that if he disqualifies Cosgrove, nobody else is going to prosecute this, and the charges are going to have to be dismissed. He knows that. Here they're huddling. They're huddling.
Thank you very much. All right, that's all we have. And just
let's pick a date.
Okay. Are you late February, March? Okay, early March. What would you like, Your Honor?
Let's go later in March.
They didn't even talk about the motion to dismiss today, which is fine.
March 27th.
Is that a Friday? Fridays are generally best.
I can do that.
It is a Friday.
Do it on a Friday.
Thank you.
I don't know if we'll be in this room. I'll have to
What did he
consult
say?
with
March
the
27th? Hold
occupant,
on.
who has generously lent me this room today.
Hold on.
With the Friday.
March 27th?
March
Is that a
27th?
Friday? Fridays are generally best.
I can do that.
2 months down the
It
road.
is a
60,
Friday.
that's another 60 days of
Do
attorney's
it on a
fees.
Friday.
Thank you.
I don't know if we'll be in this room. I'll have to consult with the occupant, who has generously lent me this room today.
I want to say one other thing, if I could,
March
Your Honor.
27th.
I am concerned that the protective orders,
I have grave concerns. Does anybody have grave concerns? This judge doesn't have grave concerns. Like, no big whoop. We can just bring in a second string guy to come in and question Lindsay Gattani, and then no big whoop, no biggie. He's got a what's his concern? What's your concern, Cosgrove? Let's hear it.
that have been issued by the court, I am concerned that the protective orders that have been issued by the court have been the subject of violations. I'm not prepared to address it today, but I want to put the defense and the court on notice that I do think there's a basis for that argument, and I will plan on raising it at the next hearing.
Well,
Oh, he's going to say that Aidan leaked stuff that was under protective order. Let's see what he says. Let's hear what the judge says.
raise it first with the other side so that they're aware of your concerns.
I will, of course.
All right. If it's not resolvable, then the court will step in.
He doesn't put things in paper on paper.
Nobody benefits by undermining the protective orders. Look, again, the way this court looks at this is that this is an important First Amendment issue which should be decided by a jury of the defendant's peers to decide the mores of our society, whether or not this is journalistic activity or it's not journalistic activity. Let's try to focus on that,
There's no privilege for
folks.
journalists in Massachusetts.
Absolutely agree with that, Your Honor.
Okay. All right. Anything else we can do today?
No, sir.
March 27th, the purpose of that hearing to be determined, but could be one of those two things.
Thank you.
Okay.
Thank you very much, Your Honor.
All right.
Your Honor.
All right, both matters continued to March 27th, time and session.
There's Will,
All right, please.
tallest guy there. That's Will LeGlaire back there.
In the courtroom at this time, please. Thank you.
Free Turtleboy, free Turtleboy, free Turtleboy.
Thank you. Please, everyone, thank you to Broken Baker. We were in a pinch, so I'm asking for forgiveness instead of permission, but I know that he would be cool with it. So right now, if everyone on your other device can go over, give Broken Baker a view on this, a like, and a sub. See if we can get his sub count up. And I'm not sure what his sub count is exactly right now, but I'll put that up here because we were chastised by the court because they don't want you to see this. They do not want you to see this. And now I can see why. The judge has already made up his mind. It's in our playlist. She's already made up her mind by Lyle Lovett. That's one of the songs on our many on the Karen Reed playlist. This is outrageous. Turtleboy is going to need donations. This is getting pushed out another 60 days. They didn't even talk about the motion to dismiss today, the big mega motion. The only thing on the table today was the motion to disqualify Cosgrove, and the judge thinks that that's a resolvable conflict. No big whoop, no biggie. We can just get another guy. We can just get another guy in here to question Lindsay Gattani, and she's not really a witness anyway. And Turtleboy made his own bed, so, he's using Lindsay Gattani. Her case is probably going to get dismissed anyway, because, I know a lot about these cases, and there's a lot of qualified immunity. And so, yeah, Broken Baker is doing the Lord's work. He's in Denmark. Let's take a look at those text messages that we brought up earlier so that you know what they were talking about, because Betero brought them up in open court. So I'm going to assume that they are legit. And you'll get an idea of what they were talking about. This goes to JenMcCabe potentially following Aidan Kearney around and stalking him. And here's what it says. Aidan posted this yesterday. On March 6th, When this screen record happened, I traveled to the Medfield police to meet up with my PI, Mark Chiappetta, where we were delivering them something for an ongoing investigation. I had initially filed a report with the Medfield PD on February 26th, and they wanted me to come back to give them something. From there, Mark and I traveled to the Dedham Police Department to file another report. After that, I traveled to Meredith's apartment in South Boston. Meredith is his ex-girlfriend. The entire time I was being stalked and followed by Jennifer McCabe, who somehow knew I was going to be at Medfield Police Department that morning. Allow me to explain. And then he posts some screenshotted messages between this PI Mark and him from March 4th of 2024, in which they talk about where they're going. And then he tells Meredith something else. Hold on one second. Let me just take this down for 1 second. He's talking to Meredith at the same time on March 6th of 2024. And apparently she's been the one who's been leaking a lot of this stuff, allegedly, because she had all of his information and access to his phone. And she may or may not have hacked into his phone. I'm not quite really sure. But here comes Lindsay Gattani with all the information. She's telling us everything. And she says, below is a screen recording from March 6th of 2024, the same day. It is a screen recording of a group text between myself, Jen McCabe, Julie Crisello, and Lisa Crisello. I'm going to post the screen recording for now. I have children to attend to and a life, but when I have time, I will return to explain away Kate's lies and the details. For now, everyone has eyeballs and, as far as I'm aware, knows how to read, right? And then she posts this screen record in which it's a message thread between this girl. I guess one of the girls is Tim Albert's longtime girlfriend. And so here it is. March 6th, 2024. This girl, Julie, says, are we planning okay doing Operation Stakeout if he does his live from him car? 8:12 a.m. Jen McCabe says, yeah, we should listen to live and make a plan. Julie says, yeah, we can get a feel for it and see what we think. And Jen McCabe says, okay. And then Julie says, if not, we can always get breakfast and mimosas somewhere. And then Lindsay says, sorry, guys, trying to rush. We woke up late this morning, but yes, I'm in. Let me text or call you once I get dropped off. And then it proceeds to another page of text messages in which Jim McCabe says at 8:35 a.m., should we go in VC, voice chat? And Jen McCabe says, Lisa, want to come get me? I will pay for gas. Just think it's best not to go in my car, right? Because Aidan knew what kind of car she had because she had a white Jeep Wrangler because he found her car sitting outside of Proctor's house one day. That's how he knew that she was meeting with Proctor. And then Julie says, I can pick you guys up at Walmart and we can go get Lindsay. And then Jen McCabe says, okay, let's go. Woohoo. At 9:06 a.m. Betterow was arguing these new messages have come out, and it's clear that Jennifer McCabe is not intimidated by Aidan Kearney because she was stalking him in March of 2024. And the judge said, well, you know, it's not really any big whoop because all that matters is whether or not she was intimidated on the dates of the alleged intimidation events. If you think you're being gaslit, you absolutely are. There's no doubt. Let's see if the screen recording says anything different. Let's put this up. Are we planning on doing Operation Stakeout if he does his live from his car? We got all that. Sorry, guys, I'm late. I'm trying to rush. There's no audio. This is just like a video of a text thread. I think his Clarence page is down, says Julie. I think he has a Facebook page called Clarence Woods Emerson. And that was at 8:29. And Jen McCabe says, really? And then Julie sends a screenshot of it and then says everything else works. And then Lisa says, wonder why. And JenMcCabe sends a screenshot about interviewing Natalie. It was another one of Aidan's shows. And then says, I can see it. And Julie says, just checked his YouTube, nothing there either. JenMcCabe says, should we go in voice chat? JenMcCabe says, Lisa wants to come. Lisa want to come get me. I'll pay for gas. Just think it's best not to go in my car. And then Julie says, I can pick you guys up at Walmart and we can get Lindsay. Lisa says, yes, we can take my car. I have to get dressed, but I have a pull-up on because I needed a pad. And Jennifer McCabe says, okay. And she says, come in, I have pads and tampons. Jury tamps in full effect. Lisa says, I'm going to try and find one pad or something. I'll get, till I get there so I can get dressed. This is way TMI. And says, I'll get ready now. Jen McCabe says, okay, let's go. Woohoo. And then Lisa says, Kay, Tally is almost ready, leaving in 5. I don't know what Tally means. Does it mean Lally? Does it mean Tully? I don't know. Is Tally somebody's name? I don't know. And then Julie posts a picture of herself giving the finger with her tongue sticking out. And then says, coming incognito. I guess they were all in costume. And Julie says, what's your location, Linz? And Lindsay says, on my way back to Medfield, going through East Westwood right now. Sorry, I was running so late this morning. That's around 9:38. Julie says, Kay, we will pick you up. And she says, okay, I'm 7 minutes away. And Julie says, Kay, we are 5 minutes from your complex. Lindsay says, Kay, hold on. Lindsay says, Kay, I'm home, sitting in my car. Let me know when you're here. And Julie says, we are parked in the back row, white sheep, with some sexy bitches inside. And Jen McCabe says, that was at 10:02. And then Jen McCabe says he was just spotted in Southie. That was 11:47. And then Lindsay says, stop, really? And then Jen McCabe says, yes, that's 11:49 a.m. And then Lisa says, never let me eat a freaking donut again. Ugh, I feel like I swallowed boulders. That's at 3:50 p.m. Yeah, Mickey Mouse pull-ups. And then something about comforters not being allowed. I don't even know what this means. These are text messages between, I think, Aidan. I don't even know what that is a screenshot of. If anybody knows, let me know. It's like something about comforters, but it's not their conversation. It looks like someone else's conversations. T-A and J-A. I don't know what that is. Nope, comforters aren't allowed. Laughy emoji. Tim says, honestly, it would have been more normal if she came out with a black guy than a comforter. This whole thing is such a loser for you guys, and you all know it, just trying to bust balls. I get it. You all know it's weird, and you all know, well, wasn't she Tim Albert's girlfriend? This girl? Okay. This whole thing is such a loser for you guys, and you all know it. Just trying to bust balls. I get it. You all know it's weird, and you all know your significant other would call in a second like you all would. Good chat, though. I don't know what that means. And Lisa says, did Lindsay know I got in trouble for bringing a comforter out of the house at 12:45 and not spying on F-Face this morning? Lindsay says, what? What was the comforter for? And then another screenshot of this message. Julie Albert, Tim Albert, and this girl, Julie. Is that who it is? J.A. is Julie Albert? I'm not sure. I can't confirm. Tim says, you guys are ridiculous. Matt probably never saw the camera yet. The only thing comparable here would be if Jen walked out with her full-fledged comforter at 12:45 in broad daylight for no reason and got in her car and Matt saw it on camera. You're telling me he'd just keep drinking his coffee and not call and ask if she was hallucinating? We know we are in the Twilight Zone already, but cut the shit. That's a different level. We sure are in the Twilight Zone. Lisa says, any information at all at 5:55 p.m., 6:12. Lindsay says nothing. And then Thursday, March 7th, Julie says, any news on the events of, oh wait, I gotta go back to the end of that. Oop. Any news on the events of the day yesterday? That's on the 7th. And Jen McCabe says, I haven't heard anything. And then all of a sudden, a photograph of Aidan Kearney's parked car shows up somewhere on Twitter. Wait, hold on. So, right. If she claims she's scared of him, why is she going after him and literally following him around with her group of girls? It's insane. It's insane. Let's go to the chat because you guys have a lot of questions and comments. V, thanks for your 5, says, I'm not a betting man, but I would bet good money there were more frostbite related Google searches on the other devices that were never taken. Thanks for your 5. True crime. Thanks for your 5 from tuning in across the pond. Tashai says, please do the House defendant's motion to dismiss. Please, I need a laugh. Maybe possibly later. I want to do the 2:00 hearing, the bond reconsideration hearing on Alex Green in front of Judge Cannoni. That's a wild story. Lindsay says, how long do these type of hearings typically take? Do we expect testimony or just a review of motions? As a ruling likely to be made today? Well, we now know that in retrospect, the judge took it under advisement. He's going to issue a ruling at some point, maybe, and everyone's going to come back on March 27th. We're maybe talking about the motion to dismiss. So no, he didn't make it from the bench. Sometimes they do. Sometimes they don't. Thank you for your 5. Thank you, Irish Wolfhound Mama, for gifting a membership. You're so generous. Gold Medal says, my son has type 1 diabetes, autoimmune versus type 2. Either way, it's pronounced diabetes, not diabetes. Well, I think it's regional. I think it depends on where you live. But if you want me to call it diabetes, I'll call it diabetes. My son's disease is life-threatening and he requires insulin daily to survive. Thank you. I'm so sorry. Prayers up for your son, Goldie Medal. And thank you so much for your super chat. Just another reminder for everyone to please sub up to Broken Baker. He's from Denmark. He's awesome. Track Worker says, this judge is a moron. What planet are we on? That's debatable. We have no idea what planet that we are on. Michelle says, Michael says, I was this year's old when I turned chocolate. Thank you very much for being here for 12 months. Kitagi says, unfortunately, we already know this is futile. He's a judge ruling on a past judge's conduct. Somebody also said that this was the judge who took over for Judge Cosgrove was a judge. He's a retired judge. This was the judge that took over for Cosgrove. He's never removing Cosgrove. Corruption runs deep. Thank you for your 10. Laws and Order says, judge must have liked the hell in that conflict of interest. Judge must have liked the hell in that conflict of interest conference. Thank you for your 5. Brenda says, this judge got Kazi's seat when he retired. That's wild to me. That is wild to me. And remember, he did tell everyone he had a conflict. I remember him saying, I am from Canton. Was that in this case or in the Karen Reed case? I am in Canton. And so I grew up in Canton. I went to Canton High and I want to disclose that. And does anybody have a problem with me sitting on this case? And they all said, no. I can't remember now because I'm conflating all of my cases. If that was this case or that was Karen Reed's case, because Belezos was on, I think, her civil case at one point, right? I don't know. Maybe I'm conflating. It was this case. Thank you, KBD. It was this case. Okay. Emma says, can Aidan appeal to a higher court to get Cosgrove off this case? This hearing is blowing my mind. Hashtag free Turtleboy. There are very limited circumstances in which you can bring an appeal before the case is concluded. I don't know if that's one of them. It may be an issue after, only if there was a conviction. And so I can't answer that question right now because we don't even have a decision on that quite yet. Thank you so much for tuning in from across the pond. Under your scars, they have failed getting Karen, and the club wants revenge, in my opinion. Welcome back to the cold weather and judicial in Massachusetts. Thank you very much for tuning in from Canada, for taking an interest in this case. And Olivia Niles here pointing out the conflict is not just exclusive to Cosgrove, but extends to the entire Norfolk DA's office. Exactly. That's why they had to hire Cosgrove. How can they reasonably even assign a new prosecutor to the case given this fact? They can't. I know. How could they? And Olivia said, controllable witness shouldn't be a concern to the prosecution if they're pursuing justice, aka the truth. No, of course not. They want a conviction. They don't care about the truth, right? Keita says the fact that Lindsay is uncontrollable is good for the defense. She will definitely go rogue on the stand and prove everyone's point. That goes to the heart of everything. Hello, Cardi B boys. Thank you for your 10. Strange Credulity, thanks for your 10, says she's accusing Tully and Cosgrove of not turning over voice messages and Tully's and Kate's messages. He took Tully's word for it that they don't exist. Right. Right. Arkansas bestie, this is crazy, right? Yeah, it's crazy. Thanks for your 20. And I thought Arkansas was bad. Arkansas is bad too. But yes, it is crazy. Sup, Bo Murdoch. And I love this username so much. But why do they call everybody Bo in the Murdoch case? In the Murdoch miniseries on Hulu anyway. It's like, hey, Bo. Hey, Bo. Says the judge already made his mind up way before today. A real Steve F says, sing it with me. Low T, Kazi G, triple dipping you and me. We are seeing the full ugliness of the administrative state. They all play for Team Commonwealth. I'll give you 5, Steve. Brenda says, buckle up, Mel. Your head's going to pop off. I'm a bit ahead. I'm not sure which point you were talking about because it popped off pretty much for the whole entire thing. And I'm behind. There's a stealing in your profile picture, but I don't know what your username is. Tie-dye man. What about Cosgrove's witness intimidation threat that he made regarding Lindsay testifying? Is that an issue that can be brought up? It was in the papers, right? Wasn't it? He basically threatened her in the response. Yeah, and he slut-shamed her. And he said that she should retain counsel if she intends to take the stand. It was threatening. They didn't talk about it orally, but it was in the papers. Wonder if it'll be in the decision. Thank you very much for your 10. Allison just says, thanks for your 5. Music to Myself says, I had the Today Show on in the background and heard Al Roker give the snow forecast for Block Island this morning. So I thought of you. You should get that clip and run it when you block trolls. That's awesome. I don't know how I can find it, but you should be getting your package today or tomorrow. I'm not sure, but it's in the mail. It went out a couple days ago, so you should be getting it soon. Let me know when you do. Thanks for your 10. BMOS says, Cosgrove, if by profit from you may defend himself, then sure. Thank you, BMOS, for your 5. Stand with Mel. Oh, that's a great username too. Says, should people who have disparaged Aidan Kearney publicly be just a bit hesitant to continue with what appears to be reason to continue this circus? I mean, wouldn't these people be subject to witness intimidation with Aidan Kearney? Same with Lindsay Gatton? No, because they selectively weaponize the law against people that they don't like, right? That's what they do. That's what they've been doing. They've been doing it for a long time. We've seen it since the Karen Reed case, and it's now continuing with Aidan Kearney. And I don't see how people who stood for Karen Reed, some of them have branched off and said they're not going to support Aidan Kearney. I don't understand it. I don't understand it. If either we're here for the First Amendment and we're here for justice or we're not. It's you can do both. You can think Aidan Kearney is a dick and still believe that he shouldn't be prosecuted selectively for a statute that nobody's been prosecuted under for speaking out about the Karen Reed case. Because I will bet you that many of you in the chat may not have known about the Karen Reed case if it wasn't for Aidan Kearney. And that is why, I don't even know if we talked about the Deadline article about the fact that Aidan has a documentary in the works and a feature film by the people who made the feature film Spotlight. Hello. Turtleboy is the story, okay? He is the story. This is a story about journalism and about corruption and about a journalist who won't shut up and wants to expose corruption, and he's being prosecuted for it. Thank you for coming to my TED Talk. Thanks for standing with Mel for your 20. And I stand with Mel says again, I stand with Melanie. I respect Melanie. I defend Melanie. Full stop. Permission for me putting this on a t-shirt. That's sweet. Thank you. Skybell gifted a membership. Thank you so much. Tiffany became a member. Welcome. Mighty Midge says the judge should ask the Commonwealth, aka the people, how we feel. It's a conflict and we don't like it. Don't trust it. Dismiss. Here's the problem. And I think the judge knows this. Yeah, you get a sofa and you get a sofa. If he conflicts Cosgrove out, Michael Marcy cannot appoint another special prosecutor. That's the problem. Because Michael Marcy is conflicted, and that is why they had to hire him in the first place. Do you think any other district attorney's office is going to touch this? No. Do you think that Michael Marcy's already announced he's not running, right? Do you think that if someone else is elected in November to take over next January 1, that these charges would be dismissed? Well, I think so. Go Adam Deitch. Thanks for your 5. User says, judge agrees there's a conflict, but let's just find a workaround because I want this trial complete ASAP. Coincidence, it's a rush before the new DA. Exactly. Those are my thoughts. I stand with Mel says, I just saw ML's head roll down my street here in Texas. Thank you. Mrs. Davis says, freedom of the press is dead. They arrested Don Lemon. Yeah, yeah, I heard that too. I haven't read about it yet because it broke. It broke while I was live with you, so I haven't seen it yet. Kelly says, Melanie, can Meredith O'Neill releasing impounded documents be an issue for Aidan? If they impute it back to him, listen, I don't know how she got it. I can't keep up on every single thing that's going on, but I don't know how she got it. If he gave it to her, if she hacked into his devices, if she's giving it to other people to publish, if he gave people other things, I don't know all the facts of it, but based on what this judge said here, it seems like he seems to think it can be a problem. And Cosgrove has said he's going to put it in writing. He's got new information that Aidan has been leaking things under protective order. That's what it sounds like. Ginny says, trying to fix the conflict with co-counsel is unbelievable, Judge. Thanks for being with me for 18 months, Ginny. Hubert's here and says it's not Julie Albert doing the stalking, it's Julie C. Lisa C's sister. Lisa is Tim Albert's girlfriend. Thanks, Mel, and have a great weekend. Yeah, I thought, was the chat saying that? We thought that the screenshotted messages that we were looking at were between Tim Albert, Julie, and there was a JA that somebody said maybe Julie Albert. I don't think she was doing any stalking. I think she may have been a participant in those text messages, but it may be somebody else named JA. I don't know. Because Julie C, it said TA, J, and JA. So I just don't know. Thank you very much. Brenda says, all local media showed up and interviewed them outside the courtroom. It's on the Glarer. Okay, we'll check that out in a moment. Thanks for your 5. Decline says, thanks for covering and your comments are amazing. Love you. Oh, I love you even more. Thank you so much. Let me see if I can get to that. All right, so wait, right now he's live from a pizza place. It's not DNA, so I don't know if that's something else. You guys should go over there and watch it after, okay? Because I'm going to teleport you to my 2:00 stream where we're going to watch the Alex Green bond hearing in front of Judge Kearney. Alex Green shot a man in the face point blank outside of an Irish pub called the Old Triangle in Hyannis. And he's out on bail because of his diabetes, because the judge said he wasn't getting treatment. So Judge Kearney let him out. The Commonwealth is appealing. It's in Plymouth Superior. I've got the Zoom info. We're going to do it at a little before 2. And I'll brief the case with you. Deborah says we can go through another judge. Bev, free Turtleboy. Thank you. Thank you very much, Deborah, for being here for 14 months. And Nicole said, missed you while you were on vacation. Thanks for sharing your trip with us. Well deserved. Today is just another example of why we love you. You're my touchstone of justice. Oh, thank you. You're a sweetheart. Thanks, Nicole, for your 10. Shari, thank you for your super sticker. Emma, thanks for tuning in from across the pond. What did the judge mean about having new counsel? The judge actually suggested that, well, we can just bring another lawyer in if Lindsay takes the stand. You can just bring in a different lawyer to question Lindsay, and Cosgrove can still be the main lawyer, and that would be okay. That's what he meant. I think that's a wild concept. I don't think that that's possible because Cosgrove would still be involved in the case, and Lindsay is still suing Cosgrove. I do not think that resolves the conflict. And I think it's wild. Okay, I got it. Turtleboy. Okay, I got it's a short clip. It's only 7 minutes, and it looks like it was the Glarer on his phone talking to the attorneys in the hallway. So thanks, Will, for granting me permission after the fact. Please also give Will the Glarer a like and a sub while we play this Turtleboy after press conference from our friend Will the Glarer.
It seemed like he was taking a, sort of active approach, poking holes, not just in your argument, but in the Commonwealth's as well.
He was a hot bench. That happens from time to time. That's what
Hot
lawyers
bench.
deal with, and you deal with it. So I don't read into it one way or the other.
You seem to give some.
He's got his camera in the wrong orientation, but there's nothing I can do about that. So just turn your head like this. Thanks, Will, for doing the Lord's work. Hold on. Take it back.
What lawyers deal with, and you deal with it. So I don't read into it one way or the other.
You seem to give some credit to a strong motion to dismiss, which of course we now at least have a date for. Thoughts on that?
It is a strong motion to dismiss, but first things first, we have to see if there's a prosecutor to even defend the motion to dismiss. If there is, then we'll come right back here at the end of March and argue why all the indictments should be dismissed. Absolutely. I think he's right.
You know, it used to be just the appearance of impropriety was enough to have somebody step aside.
Thank you, Michael
Would you
Bryant.
step aside if you were in his role?
That's Michael Bryan from Justice Served TV, Linda Kenny Bodden's partner on YouTube.
If I were sued by a witness in a case I was prosecuting back when I was a prosecutor, I personally would take the exit ramp and get out of there. Yes.
So why is he fighting so hard to stay on this case?
That's for him to answer. I don't want to speculate. We have great personal respect for Mr. Cosgrove. It has nothing to do with the position that he's in because of, a witness's accusations towards him. But I would not even pretend to try to read his mind as to why he's doing what he's doing. That's a question only he can answer.
Do you think they would struggle to find someone else to join this case? Obviously, they couldn't find someone to prosecute the 24 case that they null-prossed.
Would you do it?
I'm not a lawyer.
If you were a lawyer, that's their problem. That's a them problem, not an us problem.
How do you like his response, Cosgrove's response, when comparing the case you conflicted out of with these cases? How is that different?
To us, it's a distinction without a difference. I think we've made that point very clear in the written submissions and the oral argument today. He disagrees, as is his right. That's how litigation works. But for us, if you're being sued by a witness, you shouldn't be examining the witness and summing up on their credibility when that witness has testimony that could impeach other important witnesses. It's just, we don't think it's appropriate, but we don't decide either.
What's the case in Middlesex we keep hearing about?
I'm not sure.
There's probably one there too.
Anybody else?
He did mention that, you're close to, it seems, settling that civil case that you filed, Aidan. How does that impact what's going on here with the conflict and all that?
I don't think it impacts it at all, because it's not almost settled with him, and he's the issue.
The court's
That's Aidan speaking, and they probably should have not told him not to speak, but let's hear that again. I don't recognize that reporter's voice asking the question.
Because it's not almost settled with him, and he's the issue.
You're close to, it seems, settling that civil case that you filed, Aidan. How does
Against
that
Lindsay.
impact what's going on here with the conflict and all that?
I don't think it impacts it at all, because it's not almost settled with him, and he's the issue.
The court seemed to go into some great detail about the timing of certain events, and Cosgrove came to this late. After all, the fact is, Cosgrove is the one being sued by a potential a witness, perhaps to be cross-examined or directly examined by him. What do you think about the court's distinction they were drawing there, the timing of all these things?
I don't know that the timing per se matters. Our issue is that for one reason or another, the prosecutor, the only prosecutor on the case, we believe has a personal interest in discrediting witnesses or a witness who has sued him and defending the credibility of witnesses whose credibility will be attacked by the civil plaintiff. Whether that happened now before, his personal interest is to restore his integrity, his reputation. Anyone who is sued and accused of things has an interest in discrediting that. How do you do that when acting as a prosecutor? We just don't think that that is appropriate. There's an appearance of a conflict. And we do think it does matter that you cannot look at this in a vacuum. This case is filled with conflicts that long precede Mr. Cosgrove. The state police are involved in the conflict who should have recused themselves. The DA is not involved in this. The former special prosecutor, Ken Mello, was booted off the case for having conflicts with Ms. Gaetani. By the way, Mr. Cosgrove already had another conflict with Ms. Gaetani. I don't think you can look at this in a vacuum. The public confidence matters in a criminal proceeding, and it's flagging right now here.
And she's not a potential witness. According to Brian Tully's 911 call on Christmas Eve 2023, he called her a witness, not a potential witness, 4 times.
Right.
So she was a witness until she wasn't.
And in his affidavit, he swore in his search warrant affidavit that she was a potential witness. Not even a potential witness, she was a witness. So, there's no question she's involved in the case. It creates an appearance of impropriety. It creates an appearance of a conflict. We think that's all we need.
Yes, agreed.
And while we're here, guys, Judge Belezos said something very interesting that I want every member of the media to think about, okay?
Tell us.
He said that he thought this case should be resolved by a jury, you know, as the conscience of the community, if you will, to decide whether this is a First Amendment issue or not. Now, we think that a journalist, I think there's a few journalists here, shouldn't have to go through paying lawyers, risking their future in front of a jury. We think in this Commonwealth that judges should be a bulwark against this stuff. Judges should decide as a preliminary matter, should a journalist, should anyone speaking out, especially against the government,
Praise
have
be.
to go through this to get to a jury trial, to spend hundreds of thousands of dollars,
Right.
to spend all of this court time, years of court time.
Oh, what just happened? Oh, I got this new like browser extension. Hold for 1 second while I get back to regular speed. Hold on. Oh, please. And if mainstream media does not pick up this comment, this is an excellent comment from Tim Bradel. I'm going to take this back. You as a journalist should not have to spend hundreds of thousands of dollars defending yourself under the First Amendment. He's right. And if they don't pick it up, I mean, it's wild.
Risking their future, that I want every, here guys.
Here, listen to it
We
again.
think that's all we need. So, and while we're here, guys, Judge Belezos said something very interesting that I want every member of the media to think about, okay? He said that he thought this case should be resolved by a jury, you know, as the conscience of the community, if you will, to decide whether this is a First Amendment issue or not. Now, we think that a journalist, I think there's a few journalists here, shouldn't have to go through paying lawyers, risking their future in front of a jury. We think in this Commonwealth that judges should be a bulwark against this stuff. Judges should decide as a preliminary matter, should a journalist, should anyone speaking out, especially against the government, have to go through this to get to a jury trial.
That's right.
To spend hundreds of thousands of dollars, to spend all of this court time, years of court time, to decide if something is protected by the First Amendment. Judges in this state need to step up and stop these kinds of prosecutions. This is the most self-interested prosecution, and it's clearly viewpoint discrimination. They didn't like what Aidan was saying, so they went after him. Who else have they ever gone after in this regard? No one ever. So they're turning this statute on its head to go to suppress Aidan's viewpoint. That is wrong. We've always contended the judges in the state should take care of that. You should not have to risk the whims of a jury, the vagaries of the jury system.
That's right.
To vindicate the First Amendment.
One thing the court did seem confident in is getting this to trial as quickly as possible. What do you say for that, Aidan?
If we have to do it, we have to do it. I'm not afraid of a trial. The facts would come out, but we believe it shouldn't come to that because, like my attorney said here, time, money, still being on bail, these are things that no one should have to live with for doing acts of journalism.
Shouldn't have gotten as far as our position, guys. And, every judge wants to move the docket, though. Every judge wants to move things along. We're doing our best we can. We're not going to go to trial on this thing until every bit of discovery is in our possession. And there's still a ways to go. That's another battle we have to fight coming up. We're most interested, however, in the motion to dismiss. We want to get that going. Joseanne? All right, anybody? Everybody taken care of? We don't want to leave anybody hanging.
Pretty good. Thanks, guys.
Thank you.
Yeah.
Okay, so there you have it. Okay. All right. He's a victim, period, says Nicole. And a little cupcake pointing out that Aidan's personality is not on trial. His channel is not criminal. Thank you, Lynn, for your very generous 50 by Venmo. She says, my appreciation. I appreciate you. And each and every one of you who watches here so much. Kyla, thank you for your 20, says, thanks for spending your time with us. It is my pleasure. It is my pleasure. Tommy, thank you very much for your 25. Just says, thank you. Thank you guys for being interested in this and for taking an interest in the First Amendment and justice and for supporting Aidan Kearney, who's been doing this for 10 years before he ever came upon the Karen Reed case. I've pinned his legal fund in the chat if you care to donate, because your rights in Massachusetts are at risk here. Thank you, Jersey Queen, for gifting 5 memberships. You're amazing. Let's all go take a lunch break until 2 p.m. And we are going to come back. I think I have set this stream for, 1:45 for us to go watch Judge Cannoni reconsider the bond that she let out. She let Alex Green out on. I think I set it for 1:40 or 1:45, but don't worry, because I'm going to teleport you right over there from here so that you can hit the reminder and then come back after your lunch break. Thanks, Jersey Queen, for gifting 5. You're amazing. You're all amazing. I love each and every one of you with all of my heart. Thank you to the moderators for doing the Lord's work today. If you got timed out, it was probably by mistake. We had well over 10,000 people in here for a large part of the 3 hours and 20 minutes that we were live. And so if you're on your phone and you're moderating, you might time the wrong person out. Please show them some grace, because without my moderators, I could not do this. Stay cool, stay kind, stay classy, stay safe out there, because it's a jungle. And let's hope, buckle your seatbelts. And I think we all need a little bit of a break, because this is getting real. And it feels to me that they will do everything they can to contort themselves into a pretzel to put Aidan Kearney back in jail. And Tim Bradel is right. A jury should not be deciding this case. This is a question of law. Whether or not, in my opinion, whether or not Aidan Kearney's acts constituted witness intimidation is a question of law. He doesn't think a jury should decide it. The judge seems to think a jury should decide it. And I think that's a problem. I think we're seeing, I don't know, should I say that we're seeing more bias here? We've seen so much bias already in the Commonwealth of Massachusetts that it's outrageous. And they just don't care. They just don't care, because now it is in your face. It is all in your face. It's in my face. It's in all of our faces. And it's outrageous. I'll see you guys back in about an hour. Go have a break. Hydrate. We got a lot of more people to free. We're not done yet. Peace.